Live stream ಅಲ್ಲ ಏನಾದ್ರು ಮಾಡ್ತೀನಿ. Oh, Umashankar is also there online.
Yes. Tuesday comes. Old material, old or fresh? I told. Okay, Monday. GMCPC, RSA. RSA and GMCPC ಅಂತ. RSA ತೋಡಿ ಆಯ್ತು ಬರಲ್ಲ. Tuesday ಗ. Urgency ಹೇಳಿ ಬೇಕು.
If he is fired and they have ordered for the surveying land.
ಸರ್ವೆ ಮಾಡ್ಕೊ ಬರಲಿ ಆಮೇಲೆ ನೋಡಿ. ಅರ್ಜೆನ್ಸಿ ಆಯ್ತು. ಟ್ಯೂಸ್ಡೇ ಆಯ್ತು ಥರ್ಸ್ಡೇ ನೋಡಿ ಆಯ್ತು ನೋಡಿ ಟ್ಯೂಸ್ಡೇ ಆಯ್ತು ಫಸ್ಟ್. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು ಅಂದೆ? ಕಮಿಷನ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ? ಸರ್ವೆ ಎಲ್ಲ ಆಯ್ತಾ? ಇಲ್ಲ ಆಯ್ತು ನೋಡಿ ಥರ್ಸ್ಡೇ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಆಯ್ತು. ಅರ್ಜೆನ್ಸಿ ಏನ್ರಿ? ಎಲಿನೇಟ್ ಮಾಡಿದ್ರೆ ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್. ಆಯ್ತು ಆಯ್ತು ತೊಗೊಳ್ಳಿ ಥರ್ಸ್ಡೇ ಅರ್ಜೆನ್ಸಿ ಏನ್ ಮೇಡಮ್? ಇಂಟರ್ಫಿಯರೆನ್ಸ್. ಆಯ್ತು ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿರ್ತಾ ನಿಮ್ಗೆ? ಆಯ್ತು ತೊಗೊಳ್ಳಿ ನೋಡಿ ಹಾಕ್ಸಿ. ನೆಕ್ಸ್ಟ್ ವಾಷಿಂಗ್ ಆಫ್ FIR ನಮಗ್ ಬರಲ್ಲ. ಓಲ್ಡಾ ನಮ್ ಮುಂದೆ ಬರಲ್ಲ. ಪಕ್ಕದ ಕೋರ್ಟ್ ಇರ್ಬೇಕು ನೋಡಿ. ಪಕ್ಕದ ಕೋರ್ಟ್ ಇರ್ಬೇಕು ನೋಡಿ. ಹಾ ಹಾ ವೇಟ್ ಮಾಡಿ ಸ್ವಲ್ಪ. What is the urgency, madam? Madam, only next Thursday. Problem? Council. Some problem is there in device only?
Sorry, madam.
Let's remind you.
Page number 5 to 19.
16 and ಹೇಳಿದ್ರಲ್ರಿ. ಕೌನ್ಸಿಲ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಗಿಂತ ಲಿಸ್ಟ್ ಮಾಡಿದೀವಿ. ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ. ಮತ್ತೆ ಅಡ್ಮಿಷನ್ 2017 ಬಂದಿಲ್ಲ ಅಂತ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಂತ ಮಾಡಿದೀವಿ ಹಿಂದೆನೆ. ನೋಡೇಟ್ ನೆಕ್ಸ್ಟ್ ಬೇರೆ.
My lord, one submission, your lordship.
ಹೇಳಿ.
Serial number 15. I'm a proxy counsel. Proxy
15.
counsel. Please, your lordship. 15.
ಮಾತಾಡಿ ಹೇಳಿ.
Part at proxy counsel. The counsel on record is not well. Any day next week, your lordship. Convenient to your lordship.
Proxy counsel submits that the counsel on record is not keeping well. 6 time and hence this matter is parted, madam. 30 next week ಯಾವ್ದು ಆಗಲ್ಲ, ತುಂಬಾ ಇದೆ. ಮಧ್ಯದಲ್ಲಿ ರಜಾ ಬೇರೆ ಇದೆ ನೋಡಿ. 31st ಈ ತಿಂಗಳು ಕೆಲಸ ಆದ್ರೆ ಅದಂಗೆ ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಎಲ್ಲ ಬರೀ ರಜೆಗಳಲ್ಲಿ.
Please.
18 ಹೇಳಿ ಏನಾಗ್ಬೇಕು? ಲಾಸ್ಟ್ ಟೈಮ್ ಕೌನ್ಸಿಲ್ ಪ್ರೈಸ್ ಟೈಮ್ 2017 ಡೇಟ್ಸ್ ಕೊಡೋದಿಲ್ಲ. 6ನೇ ವರ್ಷ ಅಡ್ಮಿಷನ್. ನಿಮ್ಗೆಲ್ಲ ಏನೋ ಅನ್ಸ್ತಾ ಇರ್ಬೋದು, ನನ್ಗಂತೂ ಅನ್ಸುತ್ತೆ. ನೋ ಕೌನ್ಸಿಲ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ ಯು ಶಾರ್ಟ್ ಟೈಮ್. ಅದರ್ ಸೈಡ್ ಇದಾರಾ ಪ್ರಭಾಕರ್? ಅದರ್ ಸೈಡ್ ಇದಾರಾ? ಎಲ್ಲಿದ್ದಾರೆ ಹೇಳ್ತೀನಿ, ಬೇಡ ಈಗಿದಾರ ಕೊಡ್ತೀನಿ. ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಆಮೇಲೆ ನೋಡಿ. ಏನ್ರಿ 6 ವರ್ಷ ಆದ್ರೂ ಅಡ್ಮಿಷನ್ ಅಂತ ಟೈಮ್ ಕೇಳ್ತೀರಿ. ನೆಕ್ಸ್ಟ್
My lord, serial number 25, may I request first?
25 ಇನ್ನು ಬಂದಿಲ್ಲ. 20 to 24
5 to 30.
25 ಹೇಳಿ ಕೌನ್ಸಿಲ್ ಏನಾಗ್ಬೇಕು? 25.
My lord, I'm actually not well, my lord. I am having a sprain on the leg, so that I am unable to come before the court. I am for the respondent, my lord.
So you are for respondent.
I am for the respondent.
Inform
May I
ಮಾಡಿದಿರಾ?
pray for after any day after 23rd?
ಅದರ್ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಿರಾ?
I'll inform the other side, my lord.
ಐ ವಿಲ್ ಬೇಡ, ಮಾಡಿದ್ರೆ ಮಾತ್ರ. ಐ ವಿಲ್ ಓನ್ಲಿ ಟೈಮ್ ತಗೊಳ್ಳೋರಿಗೆ ಮಾತ್ರ. ಅದಕ್ಕೋಸ್ಕರ ಇಂಟಿಮೇಟ್ ಮಾಡಿ, then I will consider your request.
Yes, when the matter reaches, my lord, I'll.
Aye.
Lord, serial number 26, my lord. I am a practical counsel, my lord. Personally, I am a caveat respondent, my lord.
Aye,
Senior is not well, my lord.
ಆಯ್ತು,
Finally,
ಎಚ್ ವಿ
one
ಮಂಜುನಾಥ್
week-
ಹೇಳಿದಿರಾ? ಎಚ್ ವಿ ಮಂಜುನಾಥ್ ಅವ್ರಿಗೆ
Yes, my lord.
ಹೇಳಿದಿರಾ?
Yes,
ಇನ್ಫಾರ್ಮ್
my lord.
ಮಾಡಿದಿರಾ?
Yes, inform, my lord.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಿರಿ?
Yes, my lord. Yes, my lord. Senior
ಆಯ್ತು, respondent.
counsel has informed.
ಸೀನಿಯರ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಾರಾ? ಇಲ್ಲೋ ಆಮೇಲೆ ಸೀನಿಯರ್
Yes, my lord. Yes, my lord.
ಆಯ್ತು, ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time and counsel also submit that already intimated the apparent counsel by his senior and hence list this matter on ಯಾವ date madam? 31st or 31/3.
Obliged.
31 to 37.
38 to 41.
38 to 41. 52. ಇದೆಯಾ ತಗೋಬಿಡಿ.
Serial number 1.
Respond.
The appeal is allowed. The judgment and decree of the trial court dated 19/7/22 passed in OS number 453 of 2000 and the judgment and decree of the first appellate court dated 2/3/2017 passed in RA number 41 and declining to grant mandatory injunction is hereby set aside. The suit of the plaintiff in respect of mandatory injunction is allowed of granting the relief of mandatory injunction as sought in the plaint. The defendant is directed to remove the encroachment within 60 days. If the defendant fails to remove the same within 60 days, the plaintiff is at liberty to enforce the same in accordance with law.
Raja L.
Appeal is allowed. The judgment and decree dated 25/1/2017 passed in RA number 348 of 2016 is set aside and consequently the judgment and decree dated 17/1/25 passed in OS number 411 of 2017 is restored. The plaintiffs are declared as owners of the suitable property and the defendants are directed to deliver the possession of the suitable property to the plaintiff within 2 months from the date of this order. Failing which, the plaintiffs are at liberty to take the possession in accordance with law. Appeal is dismissed.
In Nagabhushan.
Yes, counsel. ಏನೋ ಮೂವ್ ಮಾಡಿದಿರಿ? ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆ. ಮತ್ತೆ ಎಸ್ಟರ್ಡೇ
ಅವರು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಪ್ರಕಾರ ಕಡಿಮೆ ಕಟ್ಟಿದ್ದಾರೆ ಇನ್ನು OS ಅಲ್ಲಿ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ. ಅದರಲ್ಲಿ 94 ಲಕ್ಷ ಇಲ್ಲ 8 ಲಕ್ಷ ಇದೆ. ಅದ್ರ ಪ್ರಕಾರ ಕಟ್ಟಬೇಕಾಗಿತ್ತು. ಅವ್ರು ಅಲ್ಲೂ 9,000
ಇಂಜೆಕ್ಷನ್ ಡಿಕ್ಲರೇಷನ್ ಇಂಜೆಕ್ಷನ್ ಅಂತ ತೋರಿಸಿದೆ. ಮಿಸ್ಟರ್ 9,000 ಕಟ್ಟಿದ್ದೀರಾ? ಇಲ್ಲಿ ಕಟ್ಟಿದಲ್ಲ ಮೇಡಮ್ 9,430 ಕಡಿಮೆ ಆಗುತ್ತಾ? ಅಂದ್ರೆ ರಾಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕಡಿಮೆ ಕಟ್ಟಿದಾರೆ ಅಂತನಾ? ನೋಡಿ ಒಂದ್ಸರಿ ಚೆಕ್ ಮಾಡಿ. ಅಡ್ವೈಲರ್ ಇದ್ರ ಪ್ರಕಾರ ನೀವು ಸರಿಯಾಗಿ ಕಟ್ಟಿಲ್ಲ ಅಂತ ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್. ಬಟ್ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ಅಂತ ತೋರಿಸ್ತಾರ್ರಿ. ಇಲ್ಲ ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್ ಅಂತೆಲ್ಲ ಇದೆ.
ಇಂಜೆಕ್ಷನ್ ಅಂತಾನೆ ಇರೋದು.
ಡಿಕ್ಲರೇಷನ್ ಇದೆಯಾ?
ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಇಂಜೆಕ್ಷನ್ ಎರಡು ಇದೆ.
ಬರೆದಿವಾಗ ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್ ಅಂತ ತೋರಿಸಿದಾರೆ. ಅದಕ್ಕೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಡಿಕ್ಲರೇಷನ್ ಆಫ್ ಟೈಟಲ್ ಅಂಡ್ ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್ ನೋಡಿ. ಅದು ಕೋರ್ಟ್ ಕಟ್ ಕೌನ್ಸಲ್ ಡೆಫಿಸಿಟ್ CF ಯಾವಾಗ ಬೇಕು? ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಯಾವಾಗ ಎಷ್ಟು ದಿವಸ ಬೇಕು? ವೆಡ್ನೆಸ್ಡೇ ರಜೆ ಇದೆ. ಥರ್ಸ್ಡೇ List this matter Thursday statement 23rd. Dismissal of appeal for non-compliance of office objection and non-payment of cost. Told. Huh? It's the time.
The last time 2000.
Told. This appeal was filed in 2017 and the matter is listed for 6th time before the court for non-compliance, and hence this court taking into note of the same with order dated 3/3/23 granted 2 weeks time. A payment of cost of ₹2,000 payable at registry, failing which the matter will be listed for dismissal on 17/3/23. And in spite of time granted, cost not paid and also office objections not complied, and hence dismissed for non-compliance of office objections and non-payment of cost. Non-producing of the acknowledgement for having served the retirement letter to the appellants as directed. Henry N. Kurtaidira. Postal track. Postal track now ಸ್ವಲ್ಪ ಬಿಲೀವ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಏನಾರು ಇದೆಯಾ ಅದ್ರಲ್ಲಿ ಏನಿರುತ್ತೆ ಅಂದ್ರೆ ಐಟಮ್ ಡೆಲಿವರ್ಡ್ ಅಂತ ಇರುತ್ತೆ, ಬಟ್ ಡೆಲಿವರಿನೇ ಆಗಿಲ್ಲ. ಮೊನ್ನೆ ಇನ್ನೊಂದು ಅದೇ ತರ ತರ್ಸ್ ನೋಡಿ, ಅದೇ ತರ ಆಗಿತ್ತು, ಡೆಲಿವರಿನೇ ಆಗಿಲ್ಲ, ವಾಪಸ್ ಬಂದಿತ್ತು. ಪೋಸ್ಟಲ್ ಟ್ರ್ಯಾಕ್ ಅಲ್ಲಿ ಡೆಲಿವರ್ಡ್ ಅಂತ ಬಂತು, ಆಮೇಲೆ ಅದು ವಾಪಸ್ ಬಂತು, ಕೋರ್ಟಿಂದ ಕಳ್ಸಿತ್ತು. ಏನಾಗಿದೆ? ಐಟಮ್ ಡೆಲಿವರಿ ಕನ್ಫರ್ಮ್ಡ್ ಅಂತಿದೆ.
ಬಂದಿದ್ರು ಇದೇ ತರ ಬರೀ ಪೋಸ್ಟ್ ಆಫೀಸ್ಗೆ ಡೆಲಿವರ್ ಆಗಿದ್ರೆ
ಅಲ್ಲಿ ಪೋಸ್ಟ್ ಆಫೀಸ್ ಡೆಲಿವರ್
ಆಗಿದ್ರು ಈ ತರ ಐಟಮ್ ಡೆಲಿವರಿ
ಏನ್ ಮಾಡ್ತಾರೆ, ಇಲ್ಲಿಂದ ಇನ್ನೊಂದು ಪೋಸ್ಟ್ ಆಫೀಸ್ ಕಳಿಸ್ತಾರಲ್ಲ, ಕನ್ಸರ್ನ್ ಪೊಲೀಸ್, ಅಲ್ಲಿ ಹೋದ್ರೆ ಪೋಸ್ಟ್ ಆಫೀಸ್ಗೆ ಅಲ್ಲಿಗೆ ರೀಚ್ ಆದ್ರೆ ಐಟಮ್ ಡೆಲಿವರ್ಡ್ ಅಂತ. ಇನ್ನೊಂದ್ಸರಿ ಕೊಡಿ ಅಷ್ಟೇ.
ಇದು ಜೀವ ಗುಬ್ಬಿ ಹೆಸರು ಮೇಲೆ ಇವ್ರ ಹೆಸರು ಏನು ಇಲ್ಲ ಇದು, ಅದ್ರಲ್ಲ ಗುಬ್ಬಿಗೆ ಹೋಗಿದೆ ಅನ್ನೋ ತರ ಇದೆ ಸರ್.
ಗುಬ್ಬಿ ಕಳ್ಸಿರೋದು ಎಲ್ಲಿಗ್ರಿ ನೀವು?
ಅದಕ್ಕೆ
ನೋಡಿ, the counsel appearing for the appellant has filed memo along with postal track wherein it is mentioned that item is delivered. The same cannot be accepted and the counsel is directed to give one more fresh notice to the appellant and produce acknowledgement. List this matter on 11/4, 1 month time irutte ನೋಡಿ. RRMS dismissal of appeal for non-compliance of office objections. Withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ? The appellant counsel has filed memo saying this court to withdraw the appeal. Does not arise. ಏನಕ್ಕೆ? Possession ತಗೋಬಿಟ್ಟಿದ್ದಾರಾ? Stating that possession already has been delivered and hence may be permitted to withdraw. And hence permitted to withdraw in terms of the memo. ಸಾಕು ಬಿದ್ದೋಗುತ್ತೆ. Krishna Bhatt. Dismissal of appeal for non-compliance of office objection, non-arraying of defendant number 5. ಹೇಳ್ರಿ. The non-arraying of defendant number 5.
Discrepancy in the ordered portion of the OS judgment to that of OS decree. In OS judgment, it is mentioned as partly decreed, but in decree portion, it is mentioned as decreed.
Decreed ಅಂತ. ಅದು ಒಂದು ವೇರಿಯೇಷನ್ಸ್ ಇದೆ ಅಂತ.
ಅದೊಂದು ಇದಕ್ಕೆ ಸಬ್ಮಿಷನ್ಸ್ ಇಟ್ಟಿದ್ದಾರೆ. ಇನ್ನೊಂದಕ್ಕೆ
defendant number 5.
ಅದಕ್ಕೆ ಸರ್.
The counsel submission regarding non-arraying of defendant number 5 is accepted. The court, the office also found that there is a discrepancy in the judgment as decreed in part and in decree it is mentioned as decreed, and there is a variance in the same. And the same is also amounts to a typographical error and hence the office objection is overruled. Our new argument and hence post the matter for admission.
Adishwara PM.
Dismissal of appeal non-compliance, huh? Yes, madam. Have you complied office objections or not? You even single also you have not complied. No, madam. No, madam. Pass over. Pass. ಒಂದು ಮಾಡಿಲ್ಲ. Pass over. ಮಾಡಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿದೀನಿ ಮಾಡಿ ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಆಗ್ಬೇಕು 1:30 2:30 ಮೇಲೆ ನೋ ಸಿಟ್ಟಿಂಗ್. ಸುಧೀಂದ್ರ ಡಿಸ್ಮಿಸಲ್ ಆಫ್ ಅಪೀಲ್ ಫಾರ್ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಾನ್ ಪೇಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಹೇಳ್ರಿ. ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿದಿರಾ ಇಲ್ಲ ಮಾಡೇ ಒಂದು ಮಾಡಿಲ್ವಾ ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀರಾ ಯಾವ್ದು ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಲಾ ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ ಚಾಯ್ಸ್ ನಿಮ್ದು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಲಾ ನೋಡ್ ದಿ ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ he has not complied with the office objections and also not paid the cost and appeal may be dismissed and hence appeal is dismissed for non-compliance of office objections and also non-payment of cost. Harish, discrepancy in the village name of respondent as in cost title of ಏನಂತಿದೆ ವೀರನ ಕೆರೆ ವೀರನ್ ಕೆರೆನಾ ಕರೆಕ್ಟ್ ಮಾಡಿ ಅಷ್ಟೇ ಅದನ್ನ ಎಲ್ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ವೀರನ ಕೆರೆ ಅಂತಿದೆ ಅದು ವೀರನ್ ಕೆರೆ ಆಯ್ತು ಬಟ್ ಅಪೀಲಲ್ಲಿ ಏನಾಯ್ತು ಸರಿ ಇದೆಯಾ ಅಪೀಲಲ್ಲೂ ಹಂಗೆ ಇದೆ ಬಟ್ ನೀವ್ ಇಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು ವೀರನ್ ಹಾಕಿರ ವೀರನ್ ಹಾಕಿ council submits that while mentioning the village name, the same is mentioned in the original suit and also the appeal as Veeranakere instead of Veeranakere. Appeal alli enide ರೀ ಇದು Veeranakere ne ಇದೆಯಲ್ಲ ಮೇಡಂ Veeranakere ne the original suit it is mentioned as Veeranakere and in the appeal it is correctly mentioned as Veeranakere and in the RSA also it is correctly mentioned as Veeranakere and hence the typographical error in mentioning the name of the village is overruled and council submission is accepted. Innondeno non filing of page number 7 of certificate narration ನೀವು ಮಾಡ್ದ ಹೋಗ್ಲಿ ಬೇಕಲ್ಲ ಫುಲ್ ಪೇಜ್ ಬೇಕಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದ್ ಪೇಜ್ ಬಿಟ್ಬಿಟ್ಟು ನಾವು ಮಾಡಕ್ಕಲ್ಲ ಒಂದ್ ತಗೊಳ್ಳಿ ಇನ್ನೊಂದ್ ತಗೊಳ್ಳಿ ಅಷ್ಟೇ ನೋಡಿ ಫಾರ್ ದಿ ಟೈಮ್ ಬೀಯಿಂಗ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್ ರಿಗಾರ್ಡಿಂಗ್ ಮಿಸ್ಸಿಂಗ್ ಆಫ್ ಪೇಜ್ ನಂಬರ್ 7 ಅಂಡ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಗೆಟ್ ದಿ full judgment and produce the same before the court and the same is required for consideration of the second appeal. The council submission is accepted for the time being. Post the matter for admission. Admission date ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್ ಎಲ್ಲ 31/3 ಯಾವ್ಯಾವ ಪೋಸ್ಟ್ ಮಾಡ್ತೀವೋ ಎಲ್ಲ 31/3 ಇಲ್ಲಾಂದ್ರೆ ಮತ್ತೆ ಬರೋದೇ ಇಲ್ಲ ಐ ಆಲ್ಸೋ 31/3 ಯಾವ್ದಾದ್ರು ಅಡ್ಮಿಷನ್ ಅಂತಾರಲ್ಲ dismissal of appeal for non-compliance of office objection third time non-payment of cost illa told ಅಲ್ವಾ this court with order dated 3/3/23 taking note of appeal was filed in 2019 and office objections are not compliant. Even matter is listed for second time before the court. The ends of justice granted 2 weeks time to comply with office objections and payment of cost of ₹1,000. And cost also not paid and office objections are also not complied in spite of matter listed for dismissal. And hence in view of the preemptory order dated 3/3/23, appeal is dismissed for non-compliance and non-payment of cost. Supreme S. Narayan, dismissal of appeal for non-compliance of office objections. Yes, counsel.
Actual number of days to be
mention ಮಾಡಿಲ್ವಾ
mention ಮಾಡಿಲ್ಲ.
ಏನನ್ನ ನೀವು 511 ದಿವಸ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದಿರಲ್ಲ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಹಾಕಿದಾರಾ ನಮ್ಮಲ್ಲಿ ಹಾಕಿರೋದ್ರಲ್ಲಿ ಇದೆಯಾ ಮೇಡಮ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲೇ ನೋಡಿ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಇದೆಯಾ ಇನ್ನಾವ್ದಿದೆ ಒಂದೇ ಇರೋದಾ The council submits that office objections are complied. ಅಷ್ಟು ಏನಾದ್ರು ಇರ್ತಾ ಇದ್ರಲ್ಲಿ ಇರ್ಲಿಲ್ವಾ? ಅಂಡ್ ಇದೆಯಾ ಮೇಡಮ್ ಮಾಡಿದ್ದಾರೆ. And office has noted that the delay has not been mentioned, but on perusal of the IA, the delay is also mentioned. And hence office objection is overruled. Post the matter for admission on 31/3. Dismissal of appeal for non-compliance office of the Pradeep M. ಅಲ್ವಾ? ಕಾಸು ಕಟ್ಟಿಲ್ವಾ? ಇಲ್ಲಿ ಹಾಕಿ ಅಲ್ಲ ಕಾಸು ಕಟ್ಟಿಲ್ಲ ಅಂತ. ಕಾಸು ಕಟ್ಟಿರ್ಬೇಕು ನೋಡಿ, ಇಲ್ಲಿ ಬರೀ ಡಿಸ್ಮಿಸಲ್ ಆಫ್ ಅಪೀಲ್ ಫಾರ್ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ದಾರೆ.
ಕಾಸು ಕಟ್ಟಿದಾರ ಬಂದಿಲ್ಲ, ಕಾಸು ಅವ್ರು ಮಾಡಿ ನೋಡೋಣ ಬರ್ತಾರಲ್ಲ. ಅದು ಒಂದು ಮಾಡಿಲ್ವಾ? ಕೊಟ್ಕೊ ಬರಲ್ಲ. ಕಾಸು ಕಟ್ಟಿದ್ರೆ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರ ಅಂತ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಕಾಸು ಅವ್ರು ಮಾಡಿ ನೋಡೋಣ, ಇಲ್ಲಾಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ at 1:30. ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್. ಆಯ್ತು, ಕಾಸು ಕಟ್ಟಿದ್ರಾ? ಕಾಸು ಕಟ್ಟಿಲ್ಲ, ಕಟ್ಟಿ ಮತ್ತೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಿದೆ ಅದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. 4ರಲ್ಲಿ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ವಾ? ಎಲ್ಲಾರ್ದು ಆಮೇಲೆ ನೋಡೋಣ. ಫಸ್ಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. ಕೌನ್ಸಿಲ್ ನೋಡಿ ಕಾಸ್ಟು ಕಟ್ಟಬೇಕು, ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕು. 4ರಲ್ಲಿ ಅಟ್ಲೀಸ್ಟ್ ಒಂದ್ 2 ಮಾಡಿ ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಇಲ್ದವ್ರು ಇಲ್ಲ, ಇಲ್ದವ್ರು ಕೊಡಲ್ಲ ಮಾಡಿ ಅಂತ ಪಾಸ್ ಓವರ್ ಮಾಡಿದೀನಿ. ಸರ್ ಅನಂತ ಕೃಷ್ಣಮೂರ್ತಿ, non-hearing of appellant number 1 to 6, 14 to 16, respond number 2 of RA. 2 ಹೌದು ಎರಡಿದೆ. ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಯಾವುದು? ಆಯ್ತು, 26 ಅಲ್ಲಿ ಇರೋರ್ನ ಎಲ್ಲಾರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿದೀರಾ? ಎಲ್ಲಾರನ್ನು ಮಾಡಿದಿರಿ. ಏನ್ ಹಾಕಿದ್ರೆ ಅಯ್ಯ ಹಾಕಿದಿರ. ಈಗ ನೀವು ಹಾಕಿರೋದು OS 26 ಅಲ್ವಾ? OS 26 ಅಲ್ಲಿ ಎಲ್ಲಾರನ್ನು ಪಾರ್ಟಿ ಇರೋರು ಮಾಡಿದಿರಾ? ಮಾಡಿದಿರಿ. ಮತ್ತೆ ಇದ್ಯಾಕೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರೈಸ್ ಮಾಡಿದಾರೆ ಮೇಡಮ್? 1 to 6 ಎಲ್ಲಿ ಬರ್ತಾರೆ ಇರೋದು?
ಸರ್ ಇನ್ನು
296 ನೋಡ್ರಿ ಬರ್ತಾರೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಅಲ್ಲಿ ಇಷ್ಟು ಜನನು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
1 ಅಪೆಲೆಂಟ್ ನಂಬರ್ 1 to 6. 14 to 16
ಯಾವ್ದ್ರ ಮೇಲೆ? ಒರಿಜಿನಲ್ ಸೂಟ್ OS 26 ಆರ್ಯನಲ್ಲಿ ಅವ್ರನ್ನೆಲ್ಲ ಪಾರ್ಟಿ ಮಾಡಿದಾರಲ್ರಿ. ಮತ್ತೆ ಆರ್ಯಾರು ಹಾಕಿದಾರಲ್ಲ. ಆಯ್ತು, ಈಗ ಅಯ್ಯ ಹಾಕಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ ಅಯ್ಯ? ಅವಾಗ ಹಾಕಿದ್ರೆ ಅಯ್ಯ ಅದು ತೋರ್ಸೇ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ. 1 of 23ನಾ? ಅಯ್ಯನಲ್ಲಿ ಏನ್ ಕೇಳಿದ್ರಿ ಪ್ರೇಯರ್? ಅದಕ್ಕೆ ಅಯ್ಯ ಹಾಕ್ಬೇಕು. ಅದಕ್ಕೆ ನಿಮ್ ಸಬ್ಮಿಷನ್ ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ. ಏನ್ ಮೇಡಮ್ ಅಯ್ಯ ಏನ್ ಡಿಲೀಟ್ಗ ಅಥವಾ?
The council for appellant has filed IA number 1 of 23 ಅಂತ.
ಇದೆಲ್ಲಿದೆ 1 of 23? ಏನ್ ಪ್ರೇಯರ್ ನೋಡಿ. ರಿಲೇಷನ್ ಕೇಳಿದಾರ ಏನು?
Instead, it is respectfully prayed may kindly be pleased to receive the fresh cost title of work.
ಫ್ರೆಶ್ ಕಾಸ್ಟ್ ರೇಟ್ ಅಂದ್ರೆ ನೀವು ಫ್ರೆಶ್ ಕಾಸ್ಟ್ ರೇಟ್ ಹಾಕ್ತೀರಾ? ಬಟ್ ಈಗ ಅಯ್ಯ ಜೊತೆ ಏನ್ ಹಾಕಿದ್ರಿ? ಫ್ರೆಶ್ ಕಾಸ್ಟ್ ರೇಟ್ ಅಂದ್ರೆ ಎಲ್ಲಿದೆ?
ಅಯ್ಯ ಜೊತೆಗೆ ಏನು ಹಾಕಿಲ್ಲ ಅದು.
ಆಯ್ತ್ರಿ, ನಂಗೆ ಅರ್ಥ ಆಯ್ತು ನೀವ್ ಹೇಳಿದ್ದು. ಬಟ್ ಈಗ ಫ್ರೆಶ್ ಕಾಸ್ಟ್ ರೇಟ್ ಹಾಕಿದೀರಾ? ಮತ್ತೆ ಯಾಕೆ ಅಯ್ಯನಲ್ಲಿ ಯಾಕೆ ಫ್ರೆಶ್ ಕಾಸ್ಟ್ ರೇಟ್ ಅಂತ ಬರ್ದ್ರಿ ಅಂತ? ಈಗ ಆಲ್ರೆಡಿ ಫೈಲ್ ಮಾಡೋದು ಅದೇನಾ?
ಸರಿ, 2 OS
ನೋಡಿ ನಿಮ್ ಏನೋ ಕ್ಲರ್ಕ್ ಏನೋ ಹೇಳ್ತಾರೆ ನೋಡಿ ಕೇಳಿ.
ಸರಿ, 2 OS
ಕ್ಲರ್ಕಿಗೆ ಗೊತ್ತಿರೋದು ಲಾಯರಿಗೆ ಗೊತ್ತಿರೋ ಕೆಲವು ಟೈಮ್.
ಸರಿ, 2 OS ಇದೆ ಅಲ್ವಾ ಸರ್? ಅದ್ರಲ್ಲಿ ಯಾವ OS ಮೇಲೆ
ಇವ್ರು OS 26 ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ ಮೇಡಮ್. ಅವ್ರು ಹೇಳೋದು 26 ಯಾರು ಇದಾರೆ ಅವ್ರನ್ನೆಲ್ಲ ಪಾರ್ಟಿ ಮಾಡಿದೀವಿ ಅಂತ. ಬಟ್ ಇಲ್ಲೇನ್ ಮಾಡಿದಾರೆ? RA ಫೈಲ್ ಮಾಡುವಾಗ ಇನ್ನೊಂದು OS 296 ಅಲ್ಲ ಅವ್ರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅದ್ ರಾಂಗ್ ಅಂತ ಹರಿಯಾಣ
ಏನು ಇಲ್ಲ ಸರ್.
prayer ಅಷ್ಟೇನೆ.
ಅದು ಅಯ್ಯ ಹಾಕಕ್ ಬರಲ್ಲ ಅಂತ.
Kindly be pleased to receive the fresh cast title as per OS 26 ಅಂತ ಇದೆ. ಅದಕ್ಕೆ fresh cast title ಹಾಕಿದೀರಾ ಅಂತೆ. ಅದೇ ನಿಮ್ ಪ್ರೇಯರ್ ಇರೋದು ಏನಂತ ಕೈಂಡ್ಲಿ ಬಿ ಪ್ಲೀಸ್ ಟು ರಿಸೀವ್ ದಿ ಫ್ರೆಶ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಂತ ಅಯ್ಯ ಹಾಕಿದಿರಿ. ಈಗ ನೀವು ಫ್ರೆಶ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಕಿದಿರ ಅಯ್ಯದು ಇದ್ರದ್ದು ಅಪೀಲ್ದು
ಸರ್ ಹಾಕಿರೋದನ್ನ accept ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹಾಕಿರೋದನ್ನೇ ನೀವು ಅಕ್ಸೆಪ್ಟ್
ಡೆಸಿಮಲ್ ಹಾಕಿರೋದು.
ಮತ್ತೆ ಇನ್ನೊಂದು ಹಾಕಿದಿರ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನಿದೆಯೋ ಅದೇ ಅದು ಹೊಸ ಫ್ರೆಶ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇಲ್ಲ.
ವಕಾಲತ್ ಹಿಂದೆ ಇಟ್ಬಿಟ್ಟು
ಕೆಳಗಡೆ ಇಟ್ಟಿದ್ದಾರೆ.
ಅದು ಹಳೇದಿರತ್ತಲ್ಲ ಸರ್ ಚೇಂಜ್ ಮಾಡಿರ್ತಾರೆ. ಇಲ್ಲಿ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಇವಾಗ ಹೊಸದು ಇಲ್ಲಿ ಫ್ರೆಶ್ ಹಾಕಿದ್ದಾರೆ. ಇದನ್ನ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಅಯ್ಯ ಹಾಕಿರೋದು. ಸರಿ ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಸರ್ ಹಾಕಿರೋದನ್ನ
ಫಸ್ಟ್ ಹಾಕಿದ್ ಇದು ಫಸ್ಟ್
ಫಸ್ಟ್ ಹಾಕಿರೋದು ಅದು ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟು ಇವಾಗ ಇಲ್ಲಿ ಹೊಸದಾಗಿ
ಬೇರೆ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಕಿದ್ರು.
ಹಾ.
Order on IA 123 and council submits that this appeal is filed in respect of OS number 26 of 2009. While filing an appeal in RA number 10092 of 2019, the parties in other suit OS number 296 of 2009 also made as parties to the proceedings. And hence there was an error in typing the cost title while filing RSA, and hence now they have filed a fresh cost title along with the IA. And in view of the IA and regions stated in the application, IA is allowed. Permitted to file a fresh cost list, cost, fresh cost title. Huh? ಅಲ್ಲ ಆಯ್ತಲ್ಲ ಅದೇ ಪರ್ಮಿಟೆಡ್ ಅಂತ ಹೇಳಿದೆ ನಾನು. Permitted to file the fresh cost title ಅಂತ ಮಾಡಿದೆ. And the same is accepted. Post the matter on. Okay, what is the urgency? ಯಾವಾಗಿದೆ ಮಂಡೇನೇ ಕೇಸ್ ಇದೆಯಾ ಅಲ್ಲಿ? ಆಯ್ತು ಮಂಡೇ. This matter on Monday.
Raghavendra Rao case.
Discrepancy in the name of appellant and respondent number 3 in this court along with counsel submission. Huh? ಗಿರೀಶ್ ಅಂತ ಇದೆ. ಏನ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಮೇಡಮ್? ಎ ಒಂದ್ ಜಾಸ್ತಿ ಬಂದಿದೆ ಅಷ್ಟೇನಾ? ಅದು ಯಾರೇ ಸ್ಕೂಟಿನಲ್ಲಿ ಕರೆಸಲಿ ಒಂದ್ಸರಿ. ಎ ಜಾಸ್ತಿ ಆದ್ರೆ ಏನಾಗುತ್ತ್ರಿ? ಗಿರೀಶ ಅಂತ ಮಾಡೋರೆ, ಗಿರೀಶ್ ಅನ್ನೋ ಬದಲು ಈಗ ಒಂಥರ ಹೊಸದಾಗಿ ಗಿರೀಶ್ ಅಂತ. ಮಾಮ್ ಅಂತಾರಲ್ಲ, ಮಾಮ್ ಅಂತಾರಲ್ಲ ಹಂಗೆ. ಅದೊಂದೇ ಮಿಸ್ಟೇಕ್ ಮೇಡಮ್. ಏ ಗಿರೀಶ ಅನ್ನೋದು ಗಿರೀಶ ಅಂತ ಹೆಸರು. ನಂದು ಮೊದ್ಲು ಹಂಗೆ ಇತ್ತು, ಸಂದೇಶ ಅಂತಿತ್ತು. The council submission is accepted, office objection is overruled. Post the matter for admission. Urgency ಇದು ಯಾವಾಗ ಬೇಕು? ಅದು ಯಾವಾಗ ಬೇಕು? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಯಾವಾಗಿದೆ ಅಂದೆ? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಯಾವಾಗಿದೆ ಅಂದೆ? 21st. This matter on 20th. 20th ಮಂಡೇ. ನಿಮ್ಗೆ ಯಾವತ್ ಬೇಕು ಹೇಳಿ? 21st. ಆಯ್ತು 21st. ನೀವು 21st ಇದೆ ಅನ್ನೋದಕ್ಕೆ ನಾನು 20th ಕೊಟ್ಟೆ. ಆಯ್ತು 21st.
Gaurav GK.
ಏನ್ರಿ ಗೌರವ್ ಇಲ್ವಾ? ಯಾರಿಲ್ವಾ? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಆಸ್ ಪರ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 3/3/23 ಕೊಡಿ. Counsel for the appellant is absent. This court, while admitting the matter in the year 2018, granted 12 weeks time to file paper book, and thereafter the matter was listed twice before the court, and in spite of it, the paper book was not filed. However, in the answer justice, 2 weeks time is granted to file the paper book. Told. This appeal was filed in the year 2017. and matter was admitted in 2018. And while admitting, 12 weeks time was given to file paper book. And thereafter also, when the matter listed twice, granted time, and in spite of it, this court on 3/3/23 also granted 2 weeks time to file paper book, and paper book not filed. And hence appeal is dismissed for non-filing of paper book. No representation of the buried madam. Court ಬರೋದು ಇಲ್ಲ. Memo for withdrawal ಏನ್ರಿ? Memo ಕೊಡಿ madam. The appellant counsel has filed memo stating that matter has been compromised and hence not pressing the appeal, and hence in view of the memo permitted to withdraw. Srinivasa DC on filing of copy of medical records with regard to the delay by the counsel for appellant as per order dated 2/3. ಸರಿ ಹೆಸರಿಗೆ ಕೊಡೋದ್ರಿ ಟೈಮ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಅನ್ಸುತ್ತೆ ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಮತ್ತೆ ಕೊಟ್ಟಿದ್ದೀವಿ ಟೈಮ್ ಹೌದಲ್ಲ ಹೆಸರಿ ಟೈಮ್ ಕೊಡ್ಬೇಕು ಹೇಳಿ ನೋ ಗ್ರೌಂಡ್ಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ ಬಿಡಿ ಪಾರ್ಟಿ ಇಸ್ ನಾಟ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಗಿವ್ ಅಗೇನ್ ಟೈಮ್ ತೋಳಿ ದಿ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅಗೇನ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ ಆಗಿರ್ಬೇಕು ಈಗೇನೋ ತಯಾರು ಮಾಡ್ತಾ ಇರ್ಬೇಕು ನೋಡಿ ಅಂತ ಇನ್ನೂ ಸ್ವಲ್ಪ ದಿವಸ ಬೇಕು ತಯಾರು ಮಾಡಕ್ಕೆ ಅಥವಾ ಏನು ಆಯ್ತು ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ once again seeks time, and this court already granted that time on 10/3/23. The counsel also submits that the appellant is not responding to his instructions. However, a bench of justice one more opportunity is given by giving 2 weeks time and this matter on 31/3. And if first Appeal. The counsel appearing to the appellant has filed memo along with memo which contains the signature of the appellant, saying this court to dismiss as not pressed, and hence appeal is dismissed as not pressed. Suresh HC. ಮೊದ್ಲೇ ಆಗಿದೆ ಇದೇನ ರಿಜೆಕ್ಷನ್ ಗಿತ್ತೇನ
ಅದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಗೆ ಆಮೇಲೆ ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಕೊಟ್ಟಿದ್ರಿ ಆಮೇಲೆ ಐಎ ಹಾಕಿದ್ರಿ
ನಾಟ್ ಪ್ರೆಸ್ ಐಎಸ್ ಆಗ್ಬೇಕು ಒಂದ್ಸಲ ಹೋಗ್ಬಿಟ್ರ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರು ಸುಬ್ರಹ್ಮಣ್ಯ ಹೊಟ್ಬಿಟ್ರ ಆಯ್ತು ಪರವಾಗಿಲ್ಲ ತವ್ರು ಅದ್ರ ಅಪೀಲ್ ಅಂತಲೇ ಬರ್ದವ್ರು ಮೇಡಮ್ ಅಪೀಲ್ ಬರೆಯಲ್ಲ ಅಪೀಲ್ ಆಲ್ರೆಡಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರು ರಿಕಾಲಿಂಗ್ ಹಾಕೊಂಡಿದ್ರು ಹಾಗೆ ಹಾಕ್ಬಿಡಿ ಫೈಲ್ಡ್ ದಿ ಮೆಮೋ ನಾಟ್ ಅಪೀಲ್ ಇಸ್ ನಾಟ್ ಬರ್ಸ್ಕೋಬೇಕು ಬರ್ತಾರ ಅವ್ರೀಗ ಮತ್ತೆ ಸಿಗ್ಬೇಕಲ್ಲ ತರ್ಸ್ಕೊಡಿ ತರ್ಸ್ಕೊಡಿ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡೋರ ನಾಟ್ ಕಂಪ್ಲೇಂಟ್ ಅದನ್ನ ಫಾಲೋ ಮಾಡಕ್ ಬರಲ್ಲ ಎಸ್ ಇಟ್ಕೊಂಡಿರಿ ಬಂದ್ರೆ ಏನಾರು ಮತ್ತೇನಾರು ಬಂದ್ರೆ ನೋಡ್ ಬರ್ಸ್ಕೊಳ್ಳಿ ಆಯ್ತು ಇಲ್ಲಾಂದ್ರೆ ನೋಡೋಣ ಇಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ ಮೇಡಮ್ ಇದು ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಅದು ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ರದ್ ಬೇಡ ನೆಕ್ಸ್ಟ್ ಎಸ್ ಮೇಡಮ್ ಹೌದು ನೋಟಿಸ್ ಟು R7 and R20 defect of files to counsel for opponent stating R13 is dead leaving behind R14 and 18 ಅವ್ರು ಅಷ್ಟೇನಾ R14 to 18 ಮಾತ್ರ ಎಲ್ಲಾರ್ ಸರ್ the counsel has filed memo stating that R13 is no more and he died leaving behind R14 to 18 14 to 18 as LRs, and hence counsel submission is accepted. Counsel memo filed by the counsel is accepted and directed to amend the cast title and file amended appeal memo within 2 weeks. Counsel 6 weeks time to pay the PF to issue notice to R7 and R20. ಒಂದು ವಾರದಲ್ಲಿ ಕೊಡ್ಬೇಕ್ರಿ ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಲ್ಲ ಇಲ್ಲ ಅವೈಟ್ ಇದು ಮೋಸ್ಟ್ಲಿ ಇಲ್ಲ ಅವೈಟ್ ಇದು ಅವೈಟಿಂಗ್ ಇದೆ ಮೇಡಮ್ ಆಯ್ತು ಅವೈಟಿಂಗ್ ನೋಟಿಸ್ ಆಫ್ R7 and R20 ಯಾವಾಗ ಹೋಗಿದೆ ನೋಡಿ ಮೇಡಮ್ ಇಶ್ಯೂ ಆಗಿರೋದು Long back. 19. 19 ಯಾಕೆ ಈಗ ಅವೈಟಿಂಗ್ ತೋರಿಸ್ತಾರೆ ಮತ್ತೆ 14th of February 14/3 ಅಲ್ಲಿ ಮೊನ್ನೆ ಇಲ್ಲ ಆಯ್ತು. ದಿ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ ಡೆಫಿಸಿಟ್ ಕೋಟಿ ಅಲ್ಲ ಮೋಸ್ಟ್ಲಿ PF paid on 14th of March 23. ಅದಕ್ಕೆ ಅವಾಯ್ಡ್ ಇರ್ಬೋದು. ಆಯ್ತು ಅವಾಯ್ಡ್ ಬೇಡ, ಇಷ್ಟ ಆಗ್ಬಿಡಿ. ಅವಾಯ್ಡ್ ನೋಟಿಸ್ ಆಫ್ R7 and R20 and this matter on April ಅಲ್ಲಿ ಕುಡಿಯೋದು. ನಿಮ್ಮ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡೋದು ಬರೆಯಲ್ವ ಮೇಡಮ್?
Notice issued to R7 service in respect of his awaiting ಅಂತ
ಸರಿ,
ಹಾಕಿದ್ದಾರೆ.
ಯಾವಾಗ ಇಶ್ಯೂಡ್ ಅಂತಿದೆ
ಅದು issued ಅಂತ ಹಾಕಿಲ್ಲ.
ನಮಗೆ
ಅದನ್ನೇ ನಾನು
ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ ಯಾವಾಗ ಅಂತ.
ಹೇಳ್ತೀನಿ. Acknowledgement
At least ನಾವು 1 month ಟೈಮ್ ಕೊಡ್ಬೇಕು ಅಂತ. 14 ರಜಾ ಇದೆ ಏಪ್ರಿಲ್ 17 ಏಪ್ರಿಲ್ 17/4. ನಾರಾಯಣ್ ಶರ್ಮಾ weeks time. Next it has refused. ಆಯ್ತು. ಆಮೇಲೆ perusal of postal shara of R5 B C and D as unclaimed. ಅದು ನೋಡಿ ಮೇಡಮ್, unclaimed ನೋಡಿ intimation ಡೆಲಿವರಿ ಆಗಿದೆಯಾ ನೋಡಿ. perusal of postal shara of R1 as dead. ನೋಡಿ. The notice issued against proposed R5A was returned with an endorsement he has refused, and hence against R5A is held sufficient. Next, the council seeks 1 week time to pay PF to issue notice to R7, R8, A and B and R9, and hence 1 week time granted to, and hence if we have paid within 1 week, issue notice against them. ಆಯ್ತಾ? ಏನಾಯ್ತು ಮೇಡಮ್?
ಹೇಗಿದೆ ಅಂದ್ರೆ ಈ ವಿಳಾಸದಾರರ ಮನೆ ನಂಬರ್ ವಾಸವಿಲ್ಲದ ಕಾರಣ ವಾಪಸ್ ಮಾಡಲಾಗಿದೆ ಅಂತ ಬಂದಿದೆ ಸರ್. ಅನ್ಕ್ಲೇಮ್ಡ್ ಅಂತ ಟಿಕ್ ಮಾಡಿದೆ.
ಅನ್ಕ್ಲೇಮ್ಡ್ ಆಗುತ್ತೆ ಮೇಡಮ್. ಖಾಲಿ ಮಾಡಿದ್ರೆ the notice issued against R5, B, C and D and R10 returned as unclaimed, but Shara discloses that they have left the address and hence left anta madidare illa anta, and hence the appellant counsel is directed to ascertain the correct address and take steps against R5, B, C and D within 2 weeks. If correct address is furnished, issue notice against them. Yes, no notice issued against R1 was returned with an endorsement is no more, and hence 2 weeks time granted to take steps against the LRs of deceased R1. Santa Madhava, sufficiency of service of notice in respect of refused R4, R12. You ಎಲ್ಲರೂ refused madam. ಅವ್ರಿಗೆ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಿ. 2 ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಅಲ್ಲ ಅವ್ರಿಗೆ ತಗೊಳ್ಳಿ, ಬಟ್ ಸತ್ತವ್ರಿಗೆ 2 ವಾರ ಕೊಡ್ತೀನಿ. ಹುಡುಕ್ಬೇಕಂದ್ರೆ ಸರಿ, ಈಗ ಎಷ್ಟು ವಾರ ಬೇಕ್ರಿ? ಆಯ್ತು. The council seeks time to issue fresh notice to R3, R6, R9, R11 and R7, and 1 week time granted, and if we have paid within 1 week, issue notice against them. It is reported that R5 and R10 are no more, and hence 3 weeks time granted to take steps against the LRs of R5 and R10. The notice issued against R4, R12, 13, 14, 15 and 16 were returned with an endorsement they have refused, and hence held sufficient against them.
R2, 7 and 8. Served.
ಆಯ್ತು, ಸರ್ವ್ಡ್ ಅಷ್ಟೇ. ಸರ್ವ್ಡ್ ಆಯ್ತಿನಲ್ಲ. ಯಾರು? ಸುಂದರೇಶ್ ಇಲ್ಲೇನಾ? ಹಾ, ಏನ ಎಲ್ಲಾರು ಯಾರ ತೀರ್ಕೊಂಡಿದಾರಲ್ಲ R1 ತೋಳಿ. The notice issued, but the council appearing to the appellant has filed IA 2 of 23 to set aside the abatement, and IA 3 of 23 for bringing LRs of deceased R1 on record. And hence issue notice against LRs of R1 on IA 3 of 2 of 23 and 2 of 3 of 23. Notice of Burley. Huh? But LRs notice of the color. ತೀರ್ಕೊಂಡವ್ರಲ್ಲ ಈಗ R1 LRs ತರ್ಬೇಕಲ್ರಿ, ಅದಕ್ಕೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ. ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ? ಈಗ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿರೋದು ಸರ್ವ್ ಆಗ್ಬೇಕಲ್ಲ, ಡಿಲೇ ಬೇರೆ ಇದೆ 201 ದಿವಸ. ಮತ್ತೆ ನೋಟಿಸ್ ಹೋಗ್ಬರ್ಲಿ. 25 ಅಂದ್ರೆ 25ರೊಳಗೆ ಹೋಗಿ ಬರೋಲ್ಲ, ಇರೋದೇ 3 ದಿವಸ. ಅಲ್ಲೇನು FDP ಹಾಕಿದಾರ ಏನು? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳಿ RSA ಹಾಕಿದೀವಿ ಅಂತ ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳಿ. ಸತ್ತೋಗಿದಾರೆ, ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಈ ಆರ್ಡರ್ ಕಾಪಿ ತಗೊಂಡಾಗ ಹಾಕಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ PF ಕೊಡಿ ಇಮಿಡಿಯೇಟ್. ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 14 ಅಲ್ಲ 13/4. ಹೇಗ್ರಿ ಆಗುತ್ತ್ರಿ? 21st ಒಳಗೆ 3 ದಿವಸದಲ್ಲಿ ಸರ್ವ್ ಆಗುತ್ತಾ? ಸರ್ವ್ ಮಾಡ್ಕೊ ಬಂದ್ರೆ ನನಗೇನಿಲ್ಲ, ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಮಾಡ್ತೀರಾ? ಆಯ್ತು ಮೇಡಮ್. And also the counsel for the counsel for an counsel for appellant is permitted to take hand summons on the LRs of the respond number 1. 25 ಇದೆಯಾ? And then list this matter on 24. ಅಷ್ಟೊಳ್ಳೆ ಮಾಡ್ಕೊ ಬರ್ಬೇಕಷ್ಟೇ. ನೋಟಿಸ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಕೋರ್ಟ್ ಬೇಡ ಮೇಡಮ್. 24th ರಜಾನ ಏನು ನಾವಿರಲ್ವಾ? 23rd ಅಲ್ಲ, ಅವ್ರಿಗೆ 25ಕ್ಕೆ ಹಿಯರಿಂಗ್ ಇದೆ. 23rd ಕೋರ್ಟ್ ನೋಟಿಸ್ ಇಲ್ಲ, ನಿಮ್ಗೆ ಹ್ಯಾಂಡ್ ಪರ್ಮಿಟೆಡ್ ಟು ಟೇಕ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಷ್ಟೇ ಮೇಡಮ್. ಕೋರ್ಟ್ ನೋಟಿಸ್ ಹೋದ್ರೆ ಮತ್ತೆ ದಾರಿ ಆಗಲ್ಲ. ಅನಿಲ್ ಕುಮಾರ್ ಎಸ್, ಅರ್ಲಿ ಹಿಯರಿಂಗ್. ಹೂ ಫೈಲ್ಡ್ ಅರ್ಲಿ ಹಿಯರಿಂಗ್? ವೈ ಮೇಡಮ್? ವೈ ಮೇಡಮ್, ವೈ ಅರ್ಲಿ ಹಿಯರಿಂಗ್? ಏನ್ರಿ ನಿಮ್ದೇನಾದ್ರು ತಕರಾರು ಇದೆಯೇನ್ರಿ? ತಗೋಬಹುದಾ? Heard on IA 1 of 22 for early hearing filed by the respondent number 1 to 3, and this RSA was filed in 2017, and for the reasons stated in the application and affidavit, IA is allowed, and the date is fixed for hearing on 31st. ಅಲ್ಲ, ಈಗ ಫಸ್ಟ್ ಅಲ್ಲಿ ಏನಿಲ್ಲ, ಎಲ್ಲ ಸರ್ವಿಸ್ ಆಗಿದೆ ಹೌದಾ? ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಏನಾಗಬೇಕು? ಸ್ಟೆಪ್ಸ್ ಟು ಬಿ ಟೇಕನ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R4 ಅನ್ಸರ್ವ್ಡ್ R4 ಅಂತಿದೆ. ಮಾಡದ್ರಿ. ಆಮೇಲೆ ನಾಳೆ ಬಂದು ಆ ಕೇಸಲ್ಲಿ ನಂಗೆ ನೋಟಿಸೇ ಬಂದಿಲ್ಲ ಅಂತಾರೆ. ಕನೆಕ್ಟೆಡ್ ಇದೆ, ಬಟ್ ಏನ್ ಮಾಡೋದು? ಅಟ್ಲೀಸ್ಟ್ ಅವ್ರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿ ನಾವು ಅವ್ರಿಗೆ ಡೈರೆಕ್ಟ್ ಮಾಡ್ಬೋದಿತ್ತು ಕೌನ್ಸಿಲ್ಗೆ. ನಾಳೆ ಬಂದು ಹೇಳ್ತಾರೆ ಇಲ್ಲ ನನಗೆ ಅದ್ರಲ್ಲಿ ಬಂದೇ ಇಲ್ಲ ಅಂತ. The counsel appearing to the appellant in RSA 1769 of 2019 submits that in connected appeal R3 Jagdisha is R4 in this appeal, and hence may be taken as held sufficient, and the said submission is not accepted since no notice has been issued in this appeal. Adi sarvagilla, and notice issued against him in this appeal was not served. The counsel orally seeks permission of this court to take the paper publication against R4 in Praja Pragati. Actually, and counsel seeks time to file necessary application, and hence list this matter. Madam, 27/3. Yes, Ganesha. ಆಯ್ತು ನೋಡಿ. ಪರ್ಮಿಷನ್ ಏನ್ರಿ? Now brought on record. The counsel appearing to the appellant would submit that the original appellant died subsequent to the judgment and decree of the appellate court. Hodalla appellate court. Original defendant athola. Alla adrallu arinallu respondent. Original defendant who has been arraigned as respondent, one in RA, passed away subsequent to the passing of judgment. Hence, an application is filed seeking permission to prosecute this appeal. And in view of the submission and also the reasons stated in the application and affidavit, permission is granted to prosecute this appeal. And accordingly, IA 1/23 is allowed. ಈಗ ಆಲ್ರೆಡಿ ಪಾರ್ಟಿ ಮಾಡಿದಿರಿ ಆಯ್ತು. ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಅದೇ ಒಟ್ಟಿಗೆ ಬರುತ್ತೆ. ಆನ್ 31(3) ಅಡ್ಮಿಷನ್ ಬಂದಾಗ ಅಲಾಂಗ್ ವಿತ್ ಐಎ ಬರುತ್ತೆ. ಪೋಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ಐಎಸ್. 15 ಅರ್ಜೆಂಟ್ 16 ಯಾರೋ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ, ಎಲ್ಲೋದ್ರು ಬಂದ್ರ ಇಲ್ಲ? ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಏನ್ ಪಾಸ್ ಅವ್ರಿ? ಹಾಫ್ ಡೇ ಇರೋದು ಇವತ್ತು. ಆರ್ಡ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. 1/7 ಶೇರ್ ಕೊಟ್ಟಿದ್ರು, ಅದು 1/28 ಅಂತ ಮಾಡಿಫೈ ಮಾಡಿದ್ದಾರೆ. ಈ ಶೆಡ್ಯೂಲ್ಡ್ ಪ್ರಾಪರ್ಟಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. 6 ವರ್ಷ ಅಪೀಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ ಅಡ್ಮಿಷನ್ ಬಂದ್ರು. So this matter was filed in the year 2017. Posted for admission on 3/3/23. Counsel was absent on that day, and hence this court made it clear in the order that if opponent counsel doesn't appear on the next date of hearing, the appeal will be dismissed for non-prosecution. And in the early morning, the counsel has made the submission that he may be given an opportunity to address the argument in the next date of hearing. Having taken note of on 3/3/23 when the matter was dismissed for first time for admission, this court has made said order, and having taken note of the same, opportunity is given as sought in the early morning, and this matter on 31/3 ಬರ್ಬೇಕು ಅಂತ ಹೇಳಿ. ಶ್ರೀ ಪ್ರಕಾಶ್ ಪರೀಕ್ಷಿತ್ partition half share allowed 1/8 and 11/14 ilva? Last time absent kodi. The appellant counsel is absent, and this court on 10/3/23 ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಡ್ಲಿಲ್ಲ, ಆದ್ರೂ ಒಂದು ಅವಕಾಶ ಕೊಟ್ರಿ. ಇವತ್ತು ಬಂದಿಲ್ಲ. ಪ್ರಕಾಶ್ ಅವ್ರ ಯಾರು ಜೊತೆ ಯಾವಾಗ ಬರ್ತಾರಲ್ರಿ ರೆಗ್ಯುಲರ್ ಆಗಿ? ಪಾಸ್ ಅವ್ರು ಮಾಡಿ ನೋಡೋಣ, ಬರ್ಲಿಲ್ಲ ಅಂತ ಡಿಸ್ಕಸ್ ಏನ್ ಮಾಡೋದು. ಎಸ್ ವಿ ಪ್ರಕಾಶ್ ಬರೋದಿಲ್ವಾ? ಸಿ ಪ್ರಕಾಶ್ ಮೊದ್ಲು ಅವರು ರೆಗ್ಯುಲರ್ ಆಗಿ ಕಂಪ್ನಿಗೆಲ್ಲ ಅಪಿಯರ್ ಆಗೋರು, ಅವರ ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪ್ನಿಗೆಲ್ಲ. ಸಿ ಪ್ರಕಾಶ್ ಹೇಳ್ರಿ. 18 ಹೇಳಿ, ಹೇಳಿದ್ರೆ ಅದರ್ ಸೈಡ್ಗೆ ಮತ್ತೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ. 2017 ರೀ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಏನಿಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು ಕಾಸ್ಟ್ ಮೇಲೆ, ಬಟ್ ಇಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಅದನ್ನ ಮಾಡಿಫೈ ಮಾಡಿ ನೋ ಕಾಸ್ಟ್ ಅಂತ ಮಾಡಿ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ. ಅಲ್ಲಿಗೆ ಏನು ಕೇಸಲ್ಲಿ ಏನು ಇಲ್ಲ, ಅದಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ ನೀವು. ಮತ್ತೆ ಹೇಳಿ ಮತ್ತೆ ಏನಿದೆ? The appellate counsel again seeks time. And earlier occasion also we have sought time and repeatedly seeking time. However, in the ends of justice, one more opportunity is given. Dismiss matter on 31-3. Huh? 29th. 29 ಜಾಸ್ತಿ ಮಾಡಿರ್ತೀವಿ ನಾವು ಅದಕ್ಕೆ. ಯಾಕೆ 31st ಇರಲ್ವಾ? ಆಯ್ತು 29-3. Yes, counsel ಹೇಳಿ. ಅಲ್ರಿ 2017 ಇನ್ನೇನ್ ಟೈಮ್? ನೀವಿದ್ದೀರಾ ಇಲ್ಲ ಯಾರೋ ಸರ್ವಣ ಅಂತಿದೆ. ಎರಡು ಕನೆಕ್ಟೆಡ್ ಇದೆಯಾ ಏನು? ಕನೆಕ್ಟೆಡ್ ಇದೆ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಯಾವುದು? 19.2 ಯಾರು ಫೈಲ್ ಮಾಡೋರು? ಸರ್ವಣ ಯಾರು ಕೌನ್ಸಿಲ್ ನೀವ? ಇದ್ರಲ್ಲಿ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಂತ ಬೇರೆ ಬರ್ತಾ ಇದೆಯಲ್ರಿ 2017 ಅಲ್ಲಿ. ಅದೇ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ 6 ವರ್ಷ ಏನಿದೆ ಮೇಡಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್? ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಮೋಸ್ಟ್ಲಿ ಬಂದಾಗ ನಾವೇನೋ ಟೈಮ್ ಕೊಟ್ಟಿದ್ವಿ. Learned counsel for the appellants in all the appeals are absent. On the previous occasion, adjourned at request of both the counsel. Learned counsel for Kevatar R3 seeks time on the ground that he has engaged a senior counsel to argue the matter. This matters on 17/3/23 ಅಂತಿದೆ. ನೋಡಿ ಈಗ ಟೈಮ್ ಕೇಳೋರು ಯಾರ್ಯಾರು? ನಿಮ್ಗೂ ಟೈಮ್ ಬೇಕಾ ಅಥವಾ ರೆಡಿನಾ? ನೀವು ರೆಡಿ ಇದ್ದೀರಿ? ನೋಡಿ, the counsel appearing for the appellant in RSA 1136 of 2017 and RSA 1135 of 2017 seeks time. It is noted that office objections as raised in RSA 113 of 1135 of 2017. Hence, the appellant counsel is directed to comply with office objections forthwith. 2017 ನೋಡಿ. The counsel appearing for the appellant in RSA 611 of 2011 also seeks time. The counsel appearing for the respondent. ಎಲ್ಲ ಮ್ಯಾಟರ್ ನೀವೇನು ಅಪಿಯರ್ ಆಗೋದು? Respondents are present. Matter is of the year 2017 and also the suit is filed for the relief of partition. And hence ಎಷ್ಟು ಸಭೆ ಕೇಳಿ? 10 days. And hence list this matter on 11/4. 11/4. ಕಂಪ್ಲೈ ಇಮಿಡಿಯೇಟ್ ಮಾಡ್ಬೇಕು. 4th week ಅಂತ ಮಾಡಿದೀನಿ, ಹೋಗಿ ಮಂಡೇನೆ ಮಾಡಿ. ಕಂಪ್ಲೈ ವಿತ್ ಇನ್ ವೀಕ್ ಅಂತ ಮಾಡಿರ್ತೀನಿ, ಮಂಡೇನೆ ಹೋಗಿ ಮಾಡಿ. ಮತ್ತಿನ್ನ ತಾರೀಗ you are whether you are seeking the counter claim ಆಯ್ತು based on the unregistered partition deed. Unregistered partition deed, if the partition is taken place based on that document, same is not admissible. ಆಯ್ತು. ಆ ಪಾರ್ಟಿಷನ್ ಮೇಲೆ ಏನಾರು ವೆದರ್ ಪಾರ್ಟೀಸ್ ಹ್ಯಾವ್ ಆಕ್ಟೆಡ್ ಅಪಾನ್ ಏನ್ ದಾಖಲೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ? RTC ಆಯ್ತು, but any mutation? RTC is the mutational. RTC ne ಬೇರೆ, mutation ne ಬೇರೆ.
Yeah, mutation. In the RTC, is part of the land. Very same land is granted to plaintiff and also the defendant. And the High Court.
Based on the land tribunal order.
81.
Have you produced that document before the court? That is exhibit D2.
So this would be here that it is the property of the plaintiff. The High Court exhibit.
ಆಯ್ತು, plaintiff ಗೆ ಎಷ್ಟು ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದಾರೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ? What is the extent? Well, now what is their claim in the permanent injunction suit? You are not disputing even the grant in favor of the plaintiff also. P126 or RTC extract, certified copy of order of land tribunal.
P2 is the 21/8/1981 order of the land tribunal. And the order of the land tribunal in favor of the plaintiff on 27/1981.
ಆಯ್ತು.
And the High Court also considered that both the lands are the same, that counterclaim land and schedule A are the same land.
But both the orders in respect of the same survey number.
And
Different portions are same, survey number same. Same land, what is the measurement? ನಿಮಗೂ ಎಷ್ಟು? ನಿಮಗೂ 1 acre 29 ಏನ? How could it be? Total, what is the total extent in that survey number 30? ಆಮೇಲೆ ನಿಮ್ ಗ್ರಾಂಟ್ ಕೂಡ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಟು ದಿ ಗ್ರಾಂಟ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿಫ್. ಅವ್ರದ್ದು 24/7/81. ಹೌದು.
That has not been.
Is there any sketch with regard to these grants?
There is no sketch. There is no sketch.
Sketch in the ಹೇಗಾಗ್ತದೆ? ಓವರ್ಲ್ಯಾಪ್ ಆಗುತ್ತಲ್ವಾ?
Exhibit D2. And based on that, exhibit D119. It is spoken to by the attesting attesting in Sunny's example.
ಏನ್ರಿ ನಿಮ್ಗೆ ಐಡೆಂಟಿಟಿ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಏನು ಗ್ರಾಂಟ್ ಇದೆ? ನಿಮ್ಗೂ ಗ್ರಾಂಟ್ ಇದೆ. ಎಕ್ಸ್ಟೆಂಟ್ ಇಸ್ 1 acre 29 ಗುಂಟಾಸ್. That is ಆಯ್ತು ಬಿಡಿ, ಪಾರ್ಟಿಷನ್ ಬಿಡಿ. ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ ಮೇಡಮ್? ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ಯಾ? ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ. Registry is directed to get the records of the trial court and also the appellate court, first appellate court, and dismiss matter along with PCR for admission on. Oh, madam, let's check put together. 13/4 ಆಗ್ತದ? 13/4. Dayamani, yes. Dismissed, confirmed with cost of rupees 3,000. Paid counsel. In part, it is declared that plaintiff is observed one of the 30 suit with respect to grant of permanent injunction is hereby dismissed. Allowed with cost accordingly. First appellate court erred in understanding the facts of the case when and discussing the facts of wrong case, as it is the plaintiff's regular appeal. Before him under challenge. Anyhow, divergent finding the issue. Urgent notice against the respondent, and in the meanwhile call for records of the trial court and also the first appellate court and list this matter for admission on 13/4. 52. Even suit for partition. Appeal is dismissed by imposing cost of 3,000 and confirmed. Send back lower court records along with copy of judgment with a direction to the learned senior civil judge to consider the directions of this court as observed in paragraph number 21 of the judgment and to report compliance of the action taken to this court. Paragraph 21 alenu. Criminal case register ಮಾಡಿ ಅಂತ. ಹೌದು. ಆಯ್ತು, ಏನ್ ದಾಖಲೆ ಏನು ಕೋರ್ಟ್ ಅಲ್ಲೇ ಟ್ಯಾಂಪರ್ ಮಾಡಿರೋದು 340 ಅಂತಂದ್ರೆ complaint to be not made under 340 of CRPC for having made a false claim punishable under section 202 of IPC. It is manifest on record that plaintiff has made a false claim before the court resulting in perjury. It would be appropriate to direct the learned civil judge before whom the said false claim was made. Then what is that false claim? Negated. Even before his birth, he also admitted the fact that the acquired and the product of the way he clearly admits that he has done the review record. Right. He also went on admitting after that, this is a matter of admitting that okay. ಏನ್ ಸ್ಟೇ ಏನಾರು ಇದೆಯಾ ಆರ್ಡರ್ ಅಲ್ಲಿ? ಸ್ಟೇ ಏನಾರು ಇದೆಯಾ ಅಂದೆ? ಅವ್ರೇನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ವ ಮತ್ತೆ ಸಿವಿಲ್ ಜಡ್ಜ್ ಸೀನಿಯರ್ ಡಿವಿಷನ್? ಸಿವಿಲ್ ಜಡ್ಜ್ ಏನಾಯ್ತು? ಹಾ ನೋಡಿ ಏನಾಗಿದೆ ವೆರಿಫೈ ಮಾಡಿ. The counsel appearing for the appellant would submit that appellant seeks time to verify whether direction issued by the appellate court to senior civil judge to consider the direction, any progress in the said direction, hence 2 weeks granted to submit same and this matter on 51(3).
23. L. Harish.
Super injunction here.
The proposal phase for already existed as on that day. And subsequently, I built a house in there in 1995. This rightly purchased property was in 1999. There was some fencing which they have removed. I kept quiet. Then they have the advantage of that proposal phase branches hanging on their side. There is a categorical admission by the plaintiff that the compound was erected by me. And the court has granted a declaration in my favor saying that the owner of the electric settled. But it has not granted the relief of possession. Because 2 court councillors are appointed. But court commissioner gave a report that has rejected the court saying that. But objected saying that there will be no labor plan has not been obtained for measurement of the stock. There were about 10 sites situated in the area. Without obtaining the labor plan, without comparing the site family with the labor plan. Because of preferred saying that there is no improvement. Then not after the second commissioner was appointed, who has submitted that he has taken the old plan, he has not taken the old plan at all. The transport phase has not looked into the statement of objection. It says that defendants are not made objection to the second commissioner. But that is totally incorrect. They have filed a statement of objection.
Whether commissioner has been examined?
No, he has not been examined. Now, based on these facts, we have table of the court commissioner. No purpose to be served for examining.
ಆರ್ಡರ್ ಕೂಡ ಏನಿರೋದು ಅಂದ್ರೆ ಕೋಕೋನಟ್ ಟ್ರೀಸ್ ಏನು ಹೆಂಗ್ ಓವರ್ ಹ್ಯಾಂಗ್ ಆಗ್ತಾ ಇದೆಯೋ ಅದನ್ನ ರಿಮೂವ್ ಮಾಡಿ.
Every year they are removing it.
Cut down the branches of the coconut tree situated on the southern side of their property and see that the said branches will not cause interference to the plaintiff for enjoyment of the social property. That is one. Restrained by way of permanent injunction from removing the fence or causing damage to the fence situated on the northern side of the social property.
And that is the reason by imposing upon
Commissioner report in. What is the report?
The enforcement cannot be noted. The answer to the memo of the plaintiff. So for the answer to the memo of the plaintiff, there is no enforcement. There are contradictory reports that are that answer given by the commissioner.
The first commissioner report is also disputed, rejected.
That has been rejected. By the
Then fresh commissioner was appointed.
appointed. There was a specific.
What is the report of the second commissioner?
He said there is no enforcement.
No encroachment.
No enforcement. Sir, I will just refer one line of the cross examination period of the one. Because you will have argued for it, because Anwar with written statement, they are trying to this case below. This case we are told what is the enforcement. Yes. Along with the written statement as well. That is ABCD is the commission for property of the defendant. Wherein the ECD has been the portion wherein the plaintiff had disclosed it to be concerned. That is the compound part. Now the transport board and the owner of ABCD. But it can't be.
But if this is the ABCD property belongs to the defendant.
That is because the court commissioner says that there is no enforcement. You can't kindly see the defendant, the mighty person, but that there is a fencing as mentioned in the written statement. That has not been mentioned in the law.
Records ಬಂದಿದೆ ಮೇಡಮ್ ಅಂತ ತೋರಿಸ್ಕೊಡ್ತೀನಿ.
All these years they have expired. Now they are finding the execution. They want to influence it, that means the also we would indicate that they are not in possession of that compound. They are saying that they are interfering with the compound, because this is in our possession only. The requesting the Partition they will directly to make this request, not the compound. Otherwise they will remove my compound. They are taking push. Recently they are taking. The Partition the Partition.
ಯಾವಾಗಿದೆ ಮ್ಯಾಟ್ರು? ಎಷ್ಟು ಯಾವಾಗಿದೆ ಮ್ಯಾಟ್? ಯಾವಾಗ ಅಂತ ಹೇಳ್ಬಿಡಿ. 19, 12, 20 ಇದೆ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಯಾವತ್ತಿದೆ ಡೇಟು? ಫಸ್ಟ್ ವೀಕ್. ಯಾವಾಗ ಹೇಳಕ್ಕಾಗುತ್ತಾ ಡೇಟು? ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ದಿಸ್ ಕೋರ್ಟ್ ವಾಂಟ್ಸ್ ಟು ಸಿ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಫಸ್ಟ್.
That no purpose will be served if the commissioner is examined. But when there is a serious objection, if cross-examining, I would have given
According to in the second commission, report is given that no encroachment.
That is because he says that we are taking the labor back. We are not taking the labor back.
Then who filed the objections to the commission report? Why?
Because we are not measured on the side of the area. He has only measures 48.
Alare, that report is in favor of youth, no encroachment. Counterclaim.
Possession is not ordered. That the entire measurement of the entire commission work is not correct because he has not.
Counterclaim of the defendant is partly allowed only to the extent for the declaration that they are the owners. ABCD portion shown in the written statement schedule, and they are not entitled for the possession of EFGH portion from the plaintiff. ಈಗ ನೀವು sketch ತೋರಿಸಿದ್ರಲ್ಲ, registry is directed to get the facts of the trial court and also the first appellate court and give the matter for admission along with records. Date ಯಾವಾಗ ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ನಾನು ನಿಮ್ಗೆ. I will not start the proceedings unless you make out a case in a case of concurrent finding.
They will not remove the compound in my court.
And the notice order agdala hege madake order na. I am not issuing any notice against the respondents. That's why I secured the record. I am ordered only for securing of records. ಯಾವಾಗಿದೆ ಹೇಳಿ, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಯಾವಾಗ. ಯಾವಾಗ ನಿಮ್ಗೂ ಡೇಟ್ ಗೊತ್ತಿಲ್ಲ. ಯಾವ ಊರಿಂದ ಬರ್ಬೇಕ್ಲೆ? ಸಾಗರ ತೀರ್ಥಹಳ್ಳಿನ ಏನೋ ನೋಡಿ, ಸಾಗರ ಇರ್ಬೇಕು. This matter on appeal, madam, 6th of April. Compliance of office objection for third time ಅಂತಿದೆ. ಆಯ್ತು. The counsel Sri Abubakar Shafi submits that he has filed a NOC wakalat yesterday na. Last year ಅಂತ. Last year ಹಾಕಿದ್ಮೇಲೆ ಈಗ ಇನ್ನೇನು ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡ್ತಾರೆ.
10th of November.
10th of November 22. 10th of November 22. 6 ತಿಂಗಳಾಯ್ತಲ್ಲ ಮತ್ತೆ ಇಂದ ಅಷ್ಟೇ ಸಭೆ ಕಂಪ್ಲೇಂಟ್ಸ್. 2017 ಮ್ಯಾಟರ್ ರೀ, ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದು ನಿಮ್ ಲುಕ್ಔಟ್, ನಮ್ದಲ್ಲ, ಅದು ಕೋರ್ಟಿಂದಲ್ಲ. ಏನು ಕೊಡದವ್ರು ನೀವು ಬ್ರೀಫ್ ಅಕ್ಸೆಪ್ಟೇ ಮಾಡಬಾರ್ದು ಅಲ್ವಾ? ದಟ್ ಈಸ್ ಯುವರ್ ಲುಕ್ಔಟ್. ಏನು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಹೇಳಂಗಿಲ್ಲ. ಮೇಡಮ್, counsel submits that he has recently filed NOC and on perusal of records he has filed the wakalat on 10th of November 2022. However, in the hands of justice, 1 week time granted to comply. 2 weeks time granted to comply with office objections. If office objection 2 weeks ಕೊಟ್ಟಿದ್ದೇನ್ರಿ, if the same is not complied within 2 weeks, list this matter for dismissal on 31/3. Registry is directed to delete the name of the counsel Jamil Pasha. 25.
My lord, 25, my lord, I sought for time in the morning.
Morning ಯಾರೋ someone sought time ಅಲ್ವಾ?
I sought for time, my lord. My lord.
Morning the Prince Isaac for R1 to 12 he sought time. And I told him that to intimate other side, then I will consider his request anta.
My lord, my lord, I'm having a hairline crack on my leg, so I'm having a pain also, unable to come to the court. So that is a request, my lord. After 23rd, any day may be happy.
But what I wish to say is,
Declaration and injunction.
declaration that I say it is not valid,
Ah.
not because of title.
Challenging the said deed.
Say it. Against 3 defendants. I am one of the defendants. He applies for another defendant. And another person applies for another. Suit got declared in the appeal.
Field. Divergent points. Other appeals ಎಲ್ಲ ಇದೆಯಾ? ಅದೇ ಕೊಡಿ, ನಂಬರ್ ಕೊಟ್ಬಿಡಿ. Appeals are allowed.
Then you should use completely to put the eggs, or you should eat completely for biryani.
ತಿಂದ್ರೆ ಒಬ್ಬರೇ ತಿನ್ಬೇಕು ಅಂತ ಅವರು. ಆಯ್ತು. RSCಗಳು ಯಾವಾಗ ಅಲವಾಗಿದ್ದು? ಕಾಂಪ್ರಮೈಸ್. ಅದನ್ನ in terms of the compromise, appeals are allowed.
Next month will be very difficult. I will start. Today, difficulty. I either start today.
ಅಲ್ಲ, ಈಗ ಅಡ್ಮಿಷನ್ ಗಿದೆ, ಈಗ ಪಾರ್ಟ್ ಔಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅದು. ಅಡ್ಮಿಟ್ ಆಗಿದೆಯಾ? ಬಟ್ ಕನೆಕ್ಟೆಡ್ ಆಲ್ರೆಡಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅಲ್ವಾ, ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು? ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ 3 ಜನ ಹಿಯರ್ ಮಾಡೋಣ, ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ ಇದ್ರೆ ಅಡ್ಮಿಟ್ ಮಾಡೋಣ, ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಇಟ್. 31st ಆಫ್ ದಿಸ್ ಮಂತ್. ಸುಮಾರೆಲ್ಲ ತುಂಬಾ ಇದೆ. 31st ಆಗ್ಬೋದಲ್ಲ? I will fix the date for 31st. 31st. Madam, more number of matters because 22nd is also holiday. We have already given dates. 31st is ideal. So the council appearing for the R1 to 12 who filed a NOC Wakalat 6 time on the ground of ill health. The council appearing for the appellant also submits that the question involved is a very narrow compass and hence
both the parties agree that they will.
then what and counsel for R13 is also present before the court and hence list this matter on 31/3. 31/3, 30th beka 30th.
Present.
Hmm. ಆಯ್ತು ಅದೇನಾಗೋದಿಲ್ಲ ಏನಾಗೋದಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಪ್ರೆಸೆಂಟ್ ಇದ್ರಾ? ಇರ್ಲಿಲ್ಲ ಅಂತಲೇನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಮಾಡಿ. ಇವತ್ತೇರ ಯಾರು ಮಾಡ್ರ ನೋಡ್ರಿ ಆರ್ಡರ್ ಶೀಟ್. ಆಯ್ತು ಬಿಡಿ ಆಯ್ತು.
Because our Rajya after 1 ವರ್ಷ ಆಗಿದೆ.
ಖಂಡಿತ ಇಲ್ಲ ಅಂದ್ರೆ ಏನಿಲ್ಲ. ಅವ್ರಿಗೆ 15 ಗುಂಟೆ ಮಾರಿದಿರಿ. ನೀವು 3/15ರಲ್ಲಿ 15 ಗುಂಟೆ ಮಾರಾಟ ಮಾಡಿದೀರಾ? ಆಯ್ತು, ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಮಾಡಿದಿರಿ. ಅದ್ರ ಮೇಲೆ ಒಂದು ಸೂಟ್ ಹಾಕೋದು. ಆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ? Now they are claiming other than 15 guntas, another 30 guntas of land based on the ಆಯ್ತು. ಅದಕ್ಕೆ ಸೂಟ್ ಹಾಕಿದೆ. ಗೆದ್ರೆ ಮಾಡಿ. ಈಗ 15 ದಿವಸ ಟೈಮ್ ಇದೆ. You can sit together and if possible you can do it. ಈಗ ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಹಾಕಿದಾರಲ್ಲ, ಅದು ದಟ್ ಇಸ್ ಅಲ್ಲ. ಆಯ್ತು ಅಲ್ಲ, ಆಯ್ತು ಅದು ಎಷ್ಟು ಹಾಕಿದ್ದಾರೆ? ಎಕ್ಸ್ಟೆಂಟ್ ಕೇಳಿದ್ದೆ 15 ಗುಂಟೆ. ಆಯ್ತು. now your claim is with regard to the ಅದೇ 15. ಈಗ ಆಲ್ರೆಡಿ 15 ಇದೆ. ಇದು ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್. ಆಯ್ತು. ಈಗ ಕಾಂಪ್ರಮೈಸ್ ಏನ್ ಹೇಳ್ತಾರೆ? ನೀವೇನ್ ಇಲ್ಲಿ 15 ಗುಂಟಾಸ್ ಇದೆ. ಇದಕ್ಕೆ ನಿಮ್ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸೇಲ್ ಡೀಡ್ ಇದೆ. ಇದಕ್ಕೆ ನಿಮ್ ತಕರಾರಿಲ್ಲ ಹೌದಾ? ಇದಕ್ಕೆ ಆಯ್ತು. ಈಗ ಆಲ್ರೆಡಿ ಸೇಲ್ ಡೀಡ್ ಇಲ್ಲಿ 15 ಗುಂಟಾಸ್ ಇದೆಯಲ್ಲ, ನೀವು ಅದು ಅವ್ರದ್ದು ಆ ಪ್ರಪೋಸಲ್ ಇದ್ರೆ ಮಾಡಕ್ಕೆ ನಿಮ್ಗೆ. ಆಯ್ತು ಮೇಡಮ್, now what do you want now? Now what do you want? Now there is a sale deed to the extent of 15 guntas.
For law, they have to get it from him. Not for
Now no dispute with regard to the 15 guntas in respect of already sale deed. ಈ 15 guntas ಅಲ್ಲ ಅರ್ಧ ಆಯ್ತು. ಈಗ 3 ಎಕರೆನು ಬೇರೆಯವ್ರಿಗೆ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ? Remaining 3 acres of land already, according to you, there was a compromise. ಅಲ್ರಿ, ನೀವು ಆಲ್ರೆಡಿ ಸೇಲ್ ಡೀಡ್ 15 ಗುಂಟಾಸ್ ಮಾಡ್ಕೊಟ್ಟಿರೋದ್ರಿಂದ ಮತ್ತೆ ಹೆಂಗ್ ನೀವು ಅದ್ರಲ್ಲಿ ಅರ್ಧ ಕ್ಲೈಮ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? I will hear the matter on 30th. If any element of settlement before that, you make settlement. If not possible, then we can. Right. We'll hear them. Yes.
From Anita, who has retained much more than my right to settle law. He has to apply myself. That was very much love.
Right, no, you both sit together, if possible, settle it, or otherwise argue matter on merits on 30th.
Grateful.
Please, counsel 30th.
Please, grateful.
That's what I.
He's also
ಅವ್ರು ಹೇಳೋದು ಇಲ್ಲೂ ಸೆಟ್ಲ್ ಆದ್ರೆ ಅಲ್ಲಿ ಸೂಟ್ ಇರೋದು ಅದು ಸೆಟ್ಲ್ ಆದಂಗ ಆಗುತ್ತೆ. ಒನ್ಸ್ ಫಾರ್ ಆಲ್ ಸೆಟ್ಲ್ಮೆಂಟ್. ಆಯ್ತು. 30th. 27 ಶಂಕರ್ ಜಿ. ಹಾಫ್ ಶೇರ್ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ. What is the finding of the trial court and first appellate court with regard to the relationship between the parties? Presume. It proves that property is ancestral joint family properties of plaintiff and defendants. Whether the plaintiff proves that he is entitled for half share in this property. Also, whether defendant proves that plaintiff is ousted from in contention, ousted from suit settled property, and thereby she had lost her share in the suit settled property. Whether the defendants prove the suit is barred by law of limitation. You never disputed the relationship between the parties. Right. What is the basis for ousting of the plaintiff? Yeah. Special power of attorney 2 and 3 MRs. 4 to 6 are 3 parties.
Husband of Gangama, and PWC is the father of this PW1, and everyone is living in the country. Based on more evidence, the driver of the time they are like even the we accept the case of an unpaid departure.
45.
To speak about the relationship of his mother and grandfather. Economic as a PW, has also got economic I think 2 to 4 and what after the mutation. You know, the son has been fathering of Gangama, but she was alive. Even Nakama was alive. During the time of life, they were not examined in the relation. Magabandu and Mama Yara. He is not doing the evidence. I mean, Jesus is happy of him. I mean, he was serving. It is the invest party. It is true that PW has argued that he has not produced any documents to show that his mother is affiliated with the family of defendants. The defendant has not rebutted.
According to your claim that you are the daughter of Chikkarangappa. Plaintiff. Ade Gangamma, she is the daughter of Chikkarangappa. They deny ಮಾಡಿರ our claim ಅಂದೆ. Case, that is the case ಅಂದೆ. ಅದೇ
based on decision, the current
ಹೌದು. ಆಯ್ತು.
Only based on moral statement from third party. ಎಲ್ಲ ಅಪ್ಪ ಮಗ ಮತ್ತೆ ಇನ್ನೊಂದು ಫಾದರ್ ಅವ್ರ ಮಾವ ಯಾರು
ಫೈಂಡಿಂಗ್ ಏನ್ರಿ ನೀವು ಫೈಂಡಿಂಗ್ ಓದೋದಿಲ್ಲ ಬರೀ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೈಂಡಿಂಗ್ ಏನ್ ಹೇಳಿ. Well, learned counsel for defendant 3 to 5 has also cross-examined PW1 and at length. It was suggested by the counsel for the defendant number 3 to 5 to PW1 that Chikkarange Gowda had only a daughter by name Shivamma. Same has been denied by PW1. PW1 has also deposed that Chikkarangappa had 2 children by name Range Gowda and Gangamma. PW1 has categorically denied the suggestion that Chikkarangappa had no daughter by name Gangamma. PW1 has admits in his cross-examination the total extent of lands also remaining with Rangappa. PW1 had denied that at no point of time mother was in possession of certain property. PW1 has also denied suggestion that plaintiff has no share in it. Specifically suggested to PW1 defendant counsel that Chikkarangappa, the father of the Gangamma, stated by him, and father of defendant Jaurappa are different family members. ಆಯ್ತು, ನಿಮ್ಮ ಪ್ರಕಾರ ನೀವು ಕ್ರಾಸ್ ಮಾಡುವಾಗ ಅವರು ಡಿಫರೆಂಟ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಅಂತ ಸಜೆಷನ್ ಮಾಡಿದಿರಿ. Plaintiff has also got examined her husband by name PW2 has by name Lakshmamma. His elder sister, and she was given in marriage to one Chikkarangaya resident of Bangalore, Bagur village. ಹೇಳ್ರಿ ಏನು 49 ಹೇಳಿ.
It is true that PW1 has agreed that he has not produced documents to show that his mother is related to the family. Next door. 52. That is not such a mama, yes, and then you traditionally relationship illa the therefore it's presumed that she is the daughter of on the next never seen the social problem and she never continued to it. PW3 has also denied solution to the physical property is not ancestral property. Not to them, not to not. But the social property that's right to do. Yes, come on. Quickly, what do they have the subsequent by counsel for friend? Nothing is related to to display the evidence. They have not very secondary, but they have to put the relationship. Not selection to the arrangement improvement to the daughter of therefore they are joint family members to joint property but possession is taken as joint possession. Court is not paid. Court is paid to section 35 class to take a joint possession. Property eventually several years. They never live with the defendant. So then universe will be the basic document. So you try for the conclusion that they are joint family. More decision is that they acquired rather than appreciating the facts of the case. Take a very decision to matter is concluded. In the truth of partition, have to look into the relationship revenue and the setup of the long time has been standing in the name of the dependents on the father. But the document was restricted that we are in possession of the property, exclusive possession that even that the real documents were not valid.
ಅದೇ ಓದ್ತಾ ಇದ್ದೀನಿ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನಿಮ್ಮ DW1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹಂಗಿಲ್ಲ ರೀ. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 16 ಓದಿ. During his cross examination, DW1 has deposed that wife of Chikkarangaya is Lakkamma. ಹೌದಾ? DW1 has also deposed his ignorance for the suggestion that plaintiff is wife of the Kambaya. ಆಯ್ತು. PW2 wife alla anta ನೀವು ಹೇಳಿದ್ರೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರಿ. DW1 has also admitted that sister of Rangayya is given in marriage to first defendant. Nimge. And page number 4 of his cross examination, DW1 has categorically admitted that name of mother of plaintiff is Lakkamma and said Lakkamma is wife of Chikkarangayya. That is her case also. He further admitted that mother of Gangamma by name Lakkamma expired on 17/3/2013 at Kadashittahalli. This admission made of DW1 is falsifies case of defendants that plaintiff is not the daughter of Chikkarangayya and his wife Lakkamma. This admission made by DW1 is best piece of evidence to prove the relationship between the parties and his Lakkamma. Therefore, it is to be held that plaintiff has proved that he is the daughter of Chikkarangayya and his wife Lakkamma. This is the finding. Admission idyo illo? Counsel, you are not answering to my question. Whether there is an admission or not. ನಾನೇ ನೋಡ್ಬಿಡ್ತೀನಿ ಬಿಡಿ ಏನಿದೆ ಅಡ್ಮಿಷನ್. ಯು ಆರ್ ನಾಟ್ ಆನ್ಸರಿಂಗ್ ಟು ಮೈ ಕ್ವೆಶ್ಚನ್. ಆಯ್ತ್ರಿ, ರಿಲೇಶನ್ಶಿಪ್ಗೆ ಅಡ್ಮಿಷನ್ ಇದ್ಮೇಲೆ ಮತ್ತೇನ್ರಿ ನಿಮ್ದು? ಅಡ್ಮಿಷನ್ admitted fact need not be proved, counsel. ಇಲ್ಲೇ ಇದೆ ನೋಡಿ, ವಾದಿ ಸದರಿ ಚಿಕ್ಕಪ್ಪ ರಂಗಪ್ಪನ ಮಗಳು ಎಂದರೆ ಸರಿಯಲ್ಲ, ಅದನ್ನು ಡಿನೈ ಮಾಡ್ತೀರಿ. ಚಿಕ್ಕರಂಗಪ್ಪರವರ ಹೆಂಡತಿ ಹೆಸರು ಲಕ್ಷ್ಮಮ್ಮ ಎಂದರೆ ಸಾಕ್ಷಿ ಲಕ್ಕಮ್ಮ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಸದರಿ ಲಕ್ಕಮ್ಮಮ್ಮ KT ಕಂಬೈನವರ ಅಕ್ಕ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ವಾದಿ ಸದರಿ KT ಕಂಬೈನವರ ಹೆಂಡತಿ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಲಕ್ಕಮ್ಮರವರನ್ನು ಬಾಗೂರಿಗೆ ಕೊಟ್ಟು ಮದುವೆ ಮಾಡಲಾಗಿತ್ತು, ಅದು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಳ್ತೀರಿ, ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದೆ. ಒಂದನೇ ಪ್ರತಿವಾದಿ ನನಗೆ ಅಣ್ಣ ರಂಗಯ್ಯರವರ ಮಗಳನ್ನು ವಾದಿಯ ಮಗನಿಗೆ ಕೊಟ್ಟು ಮದುವೆ ಮಾಡಲಾಗಿದೆ ಎಂದರೆ
ಈ ಲಕ್ಕಮ್ಮ ಯಾರು, ಆ ಲಕ್ಷ್ಮಮ್ಮ ಯಾರು, ಅಲಿಯಾಸ್ ಒಬ್ಬೊಬ್ರಿಗೆ ಎಲ್ಲ
ಗಂಗಮ್ಮ ಅವರ ತಾಯಿ ಲಕ್ಷ್ಮಮ್ಮ ಅವರು 17/3/14 ಕಾಡಶೆಟ್ಟಿಯಲ್ಲಿ ತೀರಿಕೊಂಡವರು ಎಂದರೆ ಸರಿ, ತಾಯಿ ಅಂತ ಇಲ್ಲಿ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೋತೀರಿ. ಒಬ್ಬಳೆ ಲಕ್ಷ್ಮಮ್ಮನ ಮಗಳು ಎಂದರೆ ಸಾಕ್ಷಿ ಇಬ್ಬರು ತೀರಿಕೊಂಡಿದ್ದಾರೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಮೊದಲೇ ಹೇಳಿದ್ದು ಒಬ್ಬರ ಮಗಳು ಅಂತ, ಶಿವಮ್ಮ ಮಾತ್ರ ಅಂತ. ಕೌನ್ಸಿಲ್ ರಿಲೇಶನ್ಶಿಪ್ ಇಟ್ಬಿಡಿ, ಬೇರೆದೇನಾದ್ರು ಇದಿದ್ರೆ ಹೇಳಿ ತೋರ್ಸಿ. ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ರಿಗಾರ್ಡಿಂಗ್ ರಿಲೇಶನ್ಶಿಪ್ ಇಸ್ ಕನ್ಸರ್ನ್. ವಾಟ್ ಈಸ್ ದಿ ಎರರ್? ಆಯ್ತು. ವೇರ್ ಇಸ್ ದಟ್ ಡಿಫೆನ್ಸ್? ಆಯ್ತು. ಈಗ ಅರ್ಗಿಸ್ಕೊಳಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಷ್ಟೇ. ಆಯ್ತ್ರಿ, ಯು ಹ್ಯಾವ್ ಎಂಜಾಯ್ಡ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಫಾರ್ ಎ ಲಾಂಗರ್ ಪೀರಿಯಡ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು. ನೌ ಯು ಗಿವ್ ಎ ಶೇರ್, ದಟ್ಸ್ ಆಲ್. And she is legally entitled, you give her share ಅಷ್ಟೇ. Court has to presume that it is a joint family property ಆದ್ರೆ joint possession only. ಆಯ್ತು, ನೀವು ಅವ್ರಿಗೆ ಔಸ್ಟೇಡ್ ಅಂತ ಡಿಫೆನ್ಸ್ ತಗೊಂಡಿದ್ರಲ್ಲ, ಔಸ್ಟ್ ಮಾಡಿದಕ್ಕೆ ಏನು ಮೆಟೀರಿಯಲ್ ಕೊಟ್ಟಿದ್ರು ಹೇಳಿ. ದಟ್ ಈಸ್ ಯುವರ್ ಡಿಫೆನ್ಸ್. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿರೋದು, ವೆದರ್ ಡಿಫೆಂಡೆಂಟ್ ಪ್ರೂವ್ಸ್ ದಟ್ ಪ್ಲೇಂಟಿಫ್ is ousted from suits and property and thereby she had lost her share in the suits and property ಅಂತ ಹೇಳ್ತೀರಿ. one breath ಅಲ್ಲಿ she is not the daughter of ಲಕ್ಕಮ್ಮ. ಆಯ್ತಾ? ಅದರ್ ಡಿಫೆನ್ಸ್ ಇಸ್ ದಟ್ she was ousted. ಯಾವಾಗ ಔಸ್ಟ್ ಮಾಡಿರಿ ಹೇಳಿ? ಆಯ್ತು, ಅಲ್ಲೇ ಆನ್ಸರ್ ಕೊಟ್ರಲ್ಲ ನೀವು, ಇನ್ನ ಹಾಕ್ಬೇಕು ಅವರು. ಆಯ್ತು, ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್, ಏನೋ ಹೇಳದಿದ್ಯಾ ನೀವು?
Was able to establish my name. And my son has a partner. But doing another
That is Karumbaya.
Likely moving the two properties for an. In this case, the client approved. Basic document is.
ಆಯ್ತು, ಅದೆಲ್ಲ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ಲಿ ಜಿನಾಲಜಿಕಲ್ ಟ್ರೀ, ಬಟ್ ಅಡ್ಮಿಷನ್ ಟೇಕ್ಸ್ ಅವೇ ಯುವರ್ ಕೇಸ್ ರಿಗಾರ್ಡಿಂಗ್ ರಿಲೇಶನ್ಶಿಪ್ ಇಸ್ ಕನ್ಸರ್ನ್. ನೆಕ್ಸ್ಟ್ ನೇಮ್ ಮಾತ್ರ ಹೇಳಿಲ್ರಿ, ಲಕ್ಷ್ಮಮ್ಮನ್ ಮಗಳು ಅಂತ ಹೇಳಿದಾರೆ. ಯಾಕೆ ಕೌನ್ಸಲ್ ಮತ್ ವೈ ಅಗೇನ್ ಯು ರಿಪೀಟ್ ದಟ್? ದೆನ್ ದೇರ್ ಇಸ್ ಎ ಕ್ಲಿಯರ್ ಅಡ್ಮಿಷನ್. ನೆಕ್ಸ್ಟ್ ಹೇಳಿ ಕೌನ್ಸಲ್, ಅಷ್ಟೇನಾ? ದಟ್ಸ್ ಆಲ್. This matter is listed for admission. I heard the counsel appearing for the appellant and also the counsel appearing for the respondent. The factual matters of case of the plaintiff before the trial court that suit scheduled properties are the joint family properties. Joint family property of plaintiff and defendant. And it is the claim that one Rangappa had two sons, namely Chikkarangappa and Jaurappa. The said Chikkarangappa had a son, namely Ramegoda. Chikkarangappa antide Chikkarangegoda. Title is the Chikkarangegoda. Rangappa had a son, namely Rangegoda, and a daughter by name Gangamma. That is plaintiff. Through his wife Lakshmamma. The said Chikkarangaya and his wife Lakshmamma are no more. The said Jaurappa has got two sons, namely Rangaswamy, that is first defendant, and Basavaraju, second defendant, through his wife Rangamma. The said Jaurappa and Rangamma are no more. That Rangegoda also died without marriage. The plaintiff is the daughter of late Chikkarangappa. The defendants are the sons of late Jaurappa. All of them have constituted an undivided joint family. The suit scheduled property is the ancestral and joint family property of grandfather of plaintiff and defendants. After the death of Rangappa, his sons Chikkarangappa and Jaurappa have succeeded to the suit scheduled property in joint, and they were in possession and enjoyment of the suit scheduled property. That after the death of father of plaintiff Chikkarangappa and his brother Rangegoda and said Jaurappa, that both the plaintiff and defendants have succeeded to suit scheduled property through succession. And since then, all are cultivating together in joint by raising crops in the suit scheduled property. It is also contended that there is a house constructed in the suit scheduled property about 3 decades back. The plaintiff is an innocent lady who is not having any worldly knowledge, and she doesn't know how to read and write. The defendants are intelligent persons in the family and they have managing the social property by looking after the entire affairs of the joint family. That after some days, both the defendants have developed hatredness towards plaintiff without any reasons or cause. Began to cultivate the social property for their own benefit by excluding the plaintiff. Further, that both the defendants began to mismanage the social property. When she made, and also they have joined with the revenue people and managed to obtain kata and pani in their names individually by creating a false and concocted document. Document styled as Vibhaga and got inserted their names in RTC, extract to the extent of 1 acre 25 kuntas in the name of first defendant and 1 acre 32 kuntas in the name of second defendant, with an intention to defraud the plaintiff, and created the document fraudulently. The plaintiff demanded share in the property and also conveyed several panchayats in the village and requested defendants to allot the share of plaintiff in property, for which defendants have refused to it, and hence, without any other alternative, have filed the suit. The pursuance of the suit summons defendant number 1 and 2 appeared, and subsequently defendant number 3 to 5 also brought on record. The defendant 1 and 2 have put their appearance and filed their written statement. Defendant number 1 and 2 have admitted that one Rangappa had 2 sons by name Chikkarangappa and Chaurappa. These defendants have also admitted that Chikkarangappa had a son by name Rangegoda and he died without marriage. It is also the case of the defendants that Chikkarangappa had a daughter by name Shivamma, who also died without marriage. These defendants have denied the case of plaintiff that she is the daughter of Chikkarangappa to his wife Lakshmamma. The defendants have also admitted the relationship with regard to the Chaurappa. It is also their claim that Rangegoda and the other daughter Siddha Shivamma are no more. However, they have admitted that social property was ancestral and giant family property of Rangappa, Chaurappa and Chikkarangappa. It is also their case that defendant number 1 and 2 have performed the marriage of their sisters, and sisters are living in their respective husbands, living along with their respective husbands. The defendant 1 and 2 have divided the social property as per Panchayat Paluparikat, and they are enjoying this property. And plaintiff is a stranger and she is not entitled for any share in the social property. It is also contended that defendant 1 and 2 are in joint possession and enjoyment of the social property, and plaintiff is not at all in joint possession. It is also contended that there is no joint family is in existence between the plaintiff and defendant. She is not the daughter of late Chikkarangappa and also not the member of a joint family. The third defendant has filed written statement, and defendant number 4 and 5 have adopted the written statement. The defendant number 3 to 5 also have also denied the claim of the plaintiff. They supported the case of the defendant number 1 and 2. The trial court, based on the pleadings of the parties, framed the issues. Also, it framed the additional issues, whether the defendants accuse that plaintiff is ousted from social property, thereby she has lost the share in the social property. The suit is barred by limitation. The trial court, in order to substantiate the case of the plaintiffs and defendants, allow the parties to lead evidence and plaintiff examined power of attorney as PW1 and also got examined 3 witnesses as PW2 to 4. On the other hand, the second defendant examined himself as PW1. He got marked document 9, 9 documents, that is exhibit D1 to 4, D1 to 9. The trial court, after considering both oral and documentary evidence, comes to the conclusion that suitable properties are joint family properties by answering issue number 1 as affirmative, and also answered issue number 2 and 3 accordingly, in coming to the conclusion that plaintiff is entitled for a half share in the suitable property, and answered the additional issue number 1 as negative, in coming to the conclusion that plaintiff has not been ousted as contended by the defendant. Being concluded by granting of half share in favor of the plaintiff, an appeal is filed by the defendant number 1 and 2 in RA number 88 of 2016. And in the appeal also contended that trial court has committed an error in granting the relief of partition, committed an error in coming to the conclusion that she is the daughter of Chikkarangappa, except the leading oral evidence, they have not produced any document. The very approach of the trial court is erroneous in coming to the conclusion that suitable properties are ancestral properties. Based on the pleadings in appeal, the first appellate court also formulated the point whether the trial court is justified in holding that plaintiff has proved that she is a daughter of Chikkarangappa, and whether judgment and decree of the trial court requires interference. And the reappreciation of both oral and documentary evidence, and also considering the admission elicited from the mouth of DW1. The first appellate court also confirmed the judgment of the trial court, and hence the second appeal is filed before this court. The counsel appearing for the appellant in this argument vehemently contend that both the courts have committed an error in accepting that plaintiff is the daughter of Chikkarangappa. This finding is perverse and without application of mind. Counsel also vehemently contend that no documentary proof is produced that the plaintiff is the daughter of Chikkarangappa. The trial court has committed serious error in not framing the very basic issue, imposing burden on the plaintiff to prove the relationship of plaintiff with the family of late Chikkarangappa and the defendants. Counsel also submits that the other witnesses who have been examined as PW2 to 4 are the relatives. And the court below committed an error in accepting the evidence of PW2 to 4. Counsel would vehemently contend that this court has to frame the substantive question of law that both the courts have committed an error in coming to the conclusion that the plaintiff is the daughter of Chikkarangappa without any evidence of the mother of the plaintiff, and also plaintiff has not been examined. Courts below are not justified in presuming that the joint family possession of the property. Hence, it requires interference. For contrary, the counsel appearing for the respondent would submit that even though they denied the relationship between the plaintiff and defendants, but in the class examination, DW1 has categorically admitted that with regard to the plaintiff's mother is Lakshmamma, Lakkamma. The same is discussed in paragraph number 16 of the trial court that DW1 has admitted during his cross examination that sister of Rangaya is given in marriage to first defendant, and further admitted that name of mother of plaintiff is Lakkamma. Lakkamma is wife of Chikkarangaya. Father admitted that mother of Gangamma by name Lakkamma expired on 17/3/2013 at Kadashettihalli. Hence, this admission falsifies the case of the defendant. The counsel also submit that once the relationship has been established and properties are the joint family properties, and though contended that the plaintiff has been ousted the same has not been proved. And in a case of joint family properties, the court has to presume that the parties are in joint possession of the property and existence of joint family, unless there was any separation. The counsel in support of his argument also relied upon the judgment reported in 2018 within bracket for KCCR 3774, Basanna versus Siddhamma and others, wherein court held that in a case for partition, when the plaintiff proving the suitable properties are ancestral, disputing genealogical defendants disputing the genealogical tree, but not producing any contra material, documentary evidence showing that plaintiff is member of joint family, courts below concurrently holding that plaintiff and defendant are proportionals of in the joint family. There was no earlier partition and plaintiff is entitled for proportionate share. The counsel vehemently contend that this judgment is aptly applicable to the case on hand. Having heard the respective counsel and also on perusal of material, it is the claim of the plaintiff that she is the daughter of Chikkarangappa. Also the case of the plaintiff that original propositors Rangappa having two sons, Chikkarangappa and Jaurappa. The defendants are the family of Jaurappa and plaintiff is the daughter of Chikkarangappa. The material discloses that though the defendants have denied the relationship of the plaintiff with that of the Chikkarangappa, but in the cross-examination of DW1 categorically admitted that Takama is the wife of the said Chikkarangappa, but they claims that only the Chikkarangappa had the son by name Rangekoda and also Shivamma, and both of them are no more, and disputed the relationship of this plaintiff with Chikkarangappa. But in the admission, it is clearly admitted that the mother of Rangamma, that is plaintiff by name Lakkamma, expired on 17/3/2013 at Kadashettihalli, and hence the seat this admission that mother of Rangamma by name Lakkamma expired on 17/3/2013 takes away the case of the appellants. The counsel would vehemently contend that the name of Lakkamma is common in the village, and the said submission cannot be accepted when there is a specific admission is given that the Lakkamma is the mother of the plaintiff Gangamma. They cannot dispute the same. The first appellate court also on the appreciation of evidence with regard to the relationship between the parties formulated the point number 1 and answer in affirmative, considering the material on record. The second aspect is with regard to the granting of share in favor of the plaintiff. Admittedly, the original propositors of the family is the Rangappa, and he had two sons, Ranga Chikkarangappa and also the Jaurappa. The defendants represents the family of Jaurappa, and the plaintiff represents the family of Chikkarangappa. And the very contention that she was ousted from the joint family, and no material is placed before the court that she was ousted, and no material is placed with regard to the any earlier partition between the family. But the defendants have also admitted that family properties belongs to the said Rangappa, and the legal heirs of Chikkarangappa were not alive, and hence they succeeded to the suitable property, and they got divided between defendant number 1 and 2. And when such admission is given that suitable properties are ancestral properties, and when the plaintiff has established that she is the daughter of Chikkarangappa and other legal heirs of Chikkarangappa were not there, the trial court and appellate court also rightly comes to the conclusion that plaintiff is entitled for half share in the suitable property, and hence I do not find any merit in the appeal. And both the courts have given concurrent finding with regard to the relationship between the parties and also with regard to the nature of the properties involved in the suit. Hence, no ground to admit the second appeal and frame any substantive question of law. In view of the discussions made up, I pass the following order. Appeal is dismissed. Yes, madam. 25 ಆಲ್ರೆಡಿ ಆಗೋಯ್ತಲ್ಲ. 31st ಕೊಟ್ಟಿದ್ದೆ ನಾನು. ನೀವು 30 ಆಯ್ತು, ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು, ಅದರ್ ಸೈಡ್ ಹೇಳಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ. ಅದ್ ನೋಡಿ ಮೇಡಮ್, 30th ಅಂತ ಇತ್ತು, 31st. ಎಸ್ ಕೌನ್ಸಲ್, ವೈ ಕೌನ್ಸಲ್, ಐ ಚೆಕಪ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ ಅಬ್ಸೆಂಟ್ ರೀ. ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ ಅಬ್ಸೆಂಟ್. Last time absent, this time I check up. Third, the junior counsel submits that senior counsel went to hospital for eye checkup and 6th time. And this is the appeal of the year 2019, and no further time will be granted in the next date of hearing. Is this matter on 31/3? No, sir.
For the rental amount, which was ordered to be paid.
ಅಂತ ನಿಮ್ಮ
We had what it memo date set of cases
second appeal ground entry, substantive question. What is the substantive question of law? You have paid the rent ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಿದೆ ಮೆಟೀರಿಯಲ್? ಏನಿಲ್ಲ, 2 ಕೋರ್ಟ್ ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದರಿಂದ ಡ್ಯಾಮೇಜಸ್ ಆರ್ ಬಿನ್ ಆರ್ಡರ್ಡ್. But you have not paid the amount. That's the reason only 18%. Trial court ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ಇಂಟ್ರೆಸ್ಟ್? ಅವರು 18, ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೊಟ್ಟು 18. ಆಯ್ತು. ಸೂಟ್ ಆಫ್ ದಿ ಇಯರ್ 2009 ಹೌದಾ? ಮತ್ತೆ that is the only ground. 18% of interest rate. ಕಡಿಮೆ ಮಾಡಿದಾರಲ್ಲ ಈಗ. ಹೌದು. ಅವ್ರೇನಾದ್ರು ಇದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿದಾರ? ಈ ಆರ್ಎ ಮೇಲೆ, ಆರ್ಎ ಆರ್ಡರ್ ಮೇಲೆ, ಅವರು ಆರ್ಎ ಆರ್ಡರ್ ಮೇಲೆ ಹಾಕಿದಾರ ಅಂದೆ. ಇಟ್ ವಾಸ್ ರೆಡ್ಯೂಸ್ ಟು 3 years ಅಲ್ವಾ, ಔಟ್ ಆಫ್ 6 years. ಹಾಕಿಲ್ಲ. ಚೆಕ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೋಡಿ ಮೇಡಮ್. ಆರ್ಎ ನಂಬರ್ 187 of 2018. The file of second additional district and district judge at Mysore. ಇದೇನಾ ಮೇಡಮ್ ಹಾಕಿದಾರ ಇದನ್ನ ಇದ್ ಬಿಟ್ರೆ ಬೇರೆ ಇಲ್ಲ ನೋಡ್ this matter is listed for admission. I heard the appellant counsel. The actual matter of case of the plaintiff before the trial court while seeking the relief of eviction against the appellant herein pretended that suitable property is the first floor of premises bearing number 49, having 400 square feet carpet area. Samachar building situated at Devaraja Road, Devaraja Marla, Mysore. Dependents are the tenant under the plaintiff in respect of suitable premises. The same was taken on 26/2006, period of 3 years, and rent of ₹6,000 per month. They have paid the advance amount of ₹75,000 at the time of inception of the tenancy. The tenancy has comes to an end of 26/2009. The plaintiff got issued legal notice stating that premises required to the plaintiff and terminated the tenancy on 20/10/2009, requesting the defendant to vacate and hand over the possession. He also demanded an amount of ₹1,000 per day for illegal occupation. They have given untenable reply and admitted the tenancy, which had comes to an end on 26/2009. In spite of the same, they have not vacated the suitable premises and hence suit is filed for the relief of damages. The defendants have entered appearance through counsel and filed a written statement, admitted the lease agreement dated 26/2006 and also contend that they have deposited security deposit amount of ₹75,000 and denied the other allegations. It is contended that in the agreement there was no specific clause of termination of tenancy. And with the sole intention to file an eviction, they have issued notice. Plaintiff wanted to increase the rent by 15%, but defendant without any demand from the plaintiff has been paying enhanced rent of ₹6,900 per month. July 2009, and plaintiff has been receiving the same, and the same was in accordance with oral understanding. No question of termination of tenancy. Based on the pleadings of the parties, the trial court framed the issues regarding termination of lease and whether defendant is liable to vacate the premises, whether the plaintiff is entitled for damages of ₹54,000 with interest at 18%. And also damages of ₹100 per day as claimed in the legal notice. Sorry, 1,000 per day for illegal occupation, the delivery of possession. Also, the defense of the defendants, it is the defendant's written statement. The trial court also framed the issue with regard to whether the defendant proves that though tenancy is not continued after stipulated lease period, the tenancy subsists and relationship of landlord and tenancy continues. The trial court, having considered both oral and documentary evidence of parties, answered the issues as affirmative. Also, the conclusion that once the tenancy is terminated, the very contention of defendant that tenancy subsists relationship of landlord and tenancy continued is answered as negative, and order to pay the rent at the rate of 6,900, calculated the same as damages to the tune of ₹4,97,720 and order to pay the interest at 18%. Being agreed by the judgment and decree of the trial court, an appeal is filed and the same is numbered as RA 187 of 2018. The first appellate court on reappreciation of both oral and documentary evidence formulated the point. The lower court was justified in directing the appellant to pay damages for a period from 10/10/2012 to 25/7/2015. The first appellate court on reappreciation of material available on record allowed the appeal in part. Judgment and decree of the trial court so far as it pertains to ordering damages at ₹6,900 per month for the period from 10/10/12 till 25/7/2000 is set aside. Being agreed by the said judgment and decree, the defendants have filed the present appeal questioning the judgment and decree of the trial court as well as the judgment and decree of the appellate court. And counsel would vehemently contend in the appeal that allowing of interest at 18% per annum is unjust, illegal. And also contended that appellants were voluntarily ready to pay the rent at enhanced rent of ₹6,900 after June 2009. However, the respondent has deliberately refused to accept the rent only in order to make a ground for eviction of the appellant's hearing. The appellant has rightly appreciated that respondent is a memo as on 10/10/2012. Hence cannot be, and also the order of both the courts directing to pay interest at 18% is not sustainable. The counsel would vehemently contend that this court has to frame the substantive question of law that ordering of 18% per annum interest damages is erroneous, and hence this court has to admit that frame substantive question of law. Having heard the respective counsel and also in perusal of material available on record, it is not in dispute that the appellants are the tenants of the respondent. It is also not in dispute that earlier there was an agreement for a period of 3 years. And on the expiry of 3 years period, notice was issued, also not in dispute. The rents were not paid, suit was filed before the trial court. The appellant also not disputes the fact that the rate of rent was announced to ₹6,900 per month. Not deposited the rent before the trial court. The suit was filed in the year 2009 and the same was disposed of 17th day of December 2015, and thereafter an appeal is filed. ಯಾವಾಗಲಾರು appeal ಎಲ್ಲಾರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರು ಎಲ್ಲಿ ಮಾಡಿದ್ರಿ from 2009 to 2012 ನೀವು ಕಟ್ಟ ಇಲ್ವಲ್ಲ till date of handing over the possession. ಆಯ್ತ್ರಿ, ಬಟ್ ನೀವು ರೆಂಟ್ ಕಾರ್ಡ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೋದಿತ್ತಲ್ಲ, ಎಲ್ಲಿ ಮಾಡಿದಿರಿ? Even first appellate court also held that they are not entitled for rent from 2012 because they have refused to receive the rent. 2012 ಅಲ್ಲಿಂದ ಮಾಡಿಲ್ಲ, ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಮಾಡಿಲ್ಲ ನಿಮಗೆ ಏನಾಯ್ತು ಮೇಡಮ್? thereafter 4 ಲಕ್ಷ ತೆಗ್ದಿದ್ದಾರ್ರಿ, ಅದನ್ನ ತೆಗ್ದು ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಓನ್ಲಿ ಪೀರಿಯಡ್ ಇಸ್ ಮೆನ್ಷನ್ಡ್ ಅಷ್ಟೇ ದಟ್ಸ್ ಆಲ್. ಏನಾಯ್ತು ಮೇಡಮ್? 2009 and disposed of in the year 2015 and appeal was filed in 2018. The same was also disposed of on 27th day of October 2018. The first appellate court also, considering the material available on record and formulated the point whether the respondent owner are entitled for rent for a period from 2012 to 2015. And having taken note of the key was offered The owner has not taken the keys and possession from the appellant, and hence reverse the finding of the trial court and made it clear in the appeal that they are entitled for interest for our rent only for the earlier period and not entitled for the rent at the rate of ₹6,900 per month for the period from 10/10/2012 till 25/7/2015, and set aside the order of the trial court. Having considered the material on record when the rents are not paid and arrears of rent, the amount is also not deposited and the same is not placed any material before the respective courts. I do not find any error committed by the trial court and also the first appellate court in directing to pay the arrears of rent with the 18% of interest when the default has been committed by the appellant. And hence, this court also invokes section 100 to admit the second appeal and frame substantive question of law with regard to the interest is a party is concerned, and hence no grounds are made out. Frame substantive question of law. If you have discussions made of appeal is dismissed. SV Shastri.
Appear for the Lord in this case. Not appear for the appellant in this.
ಹೌದ್ರಿ ನೀವು ಬರೀ ಬಿಲ್ಡಿಂಗ್ ಇಟ್ಕೊಳ್ಳೋದಲ್ಲ ರೆಂಟ್ ಕಟ್ಟಬೇಕು. ಎಲ್ಲಿದೆ ಪ್ರೂಫ್ ಕೊಟ್ಟೇ ಇಲ್ವಲ್ಲ ನೀವು? ಹೋಟೆಲ್ ಹಾಕ್ಬೇಕ್ರಿ ನೀವು, ಎಲ್ಲಿ ಹಾಕಿದ್ರಿ ನೀವು? ಏನು ಇಲ್ಲ, ನಿಮ್ ಗ್ರೌಂಡ್ ಇಲ್ಲ. have you pleaded in your pleading at least ground ಅಲ್ಲಿ ಇಲ್ಲ ರೆಂಟ್ ನಾವು ಪೂರ್ತಿ ಕಟ್ಬಿಟ್ಟಿದೀವಿ ಅರಿಯರ್ಸ್ ಇರ್ಲಿಲ್ಲ ಅಂತ? ಇಲ್ಲ. ನೋ, ನಾನು ದಟ್ಸ್ ವೈ ಐ ರೆಡ್ ಯುವರ್ ಗ್ರೌಂಡ್ಸ್ ಆಲ್ಸೋ. ಆಯ್ತ್ರಿ, ಅದ್ ಅಲ್ಲಿ ಕೊಡ್ಬೇಕು. ಇಲ್ಲಲ್ಲ, ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲ, ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಡ್ಬೇಕಿತ್ತು. ಇಲ್ಲೆಲ್ಲ ನಾವು ರೆಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ ಅಂತ. ವೆನ್ ದೇ ಹ್ಯಾವ್ ಕ್ಲೈಮ್ಡ್ ದಿ ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್, ನೀವು ಕೊಡ್ಬೇಕು ಅಲ್ಲಿ. ಅಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ? ಏನ್ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ನಿಮಗೆ ಚಾನ್ಸ್ ಕೊಡ್ಬೇಕಾ? ಆಯ್ತು, ನಾನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದೀನಿ. ನಿಮ್ ಕಾನೂನು ಏನಿದೆ ತಗೊಂಡೋಗಿ, ಇಲ್ಲಿ ತಗೊಂಡೋಗಿ. ನೋ ಕೌನ್ಸಿಲ್.
In next matter, I appear for appellant in this case. 30th.
ಯಾವ್ದು? 30. ಹೇಳಿ.
My lord, earlier on 9th, my lord, your lordship in similar identical matter has dismissed the appeal, my lord. I have requested to tag all this matter because 10 matters has been filed before your lordship.
ಈಗ 808 ಇದೆ, ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗ್ಲೇಬೇಕು. ಅದಕ್ಕೆ ನಾನು ಏನು
ಏನ್ ಮಾಡ್ಬೇಕು?
ಫಸ್ಟ್ 810 ಅಲ್ಲಿ ಆಗಿರೋದೇ ಆಗಿದೆ.
ಆರ್ಡರ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ.
your lordship has 9/3 your lordship has passed the order.
ಸಿಮಿಲರ್ ಆರ್ಡರ್.
ಹೌದು, ಅದರಲ್ಲಿ ಬಟ್ only my lord the party's name will change and site number will change and schedule property will change.
ನೋಡಿ ಮೇಡಮ್, ಅದು ಸಿಮಿಲರ್ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ. ಆ ನಂಬರ್ ಹೇಳಿ.
My lord, RSA 810 my lord 810 of 2019. My lord, your lordship has passed the order on my lord 9/3/23 my lord.
ತಗೊಳ್ಳಿ ಮೇಡಮ್, 9/3 ಪಾರ್ಟೀಸ್ ಎಲ್ಲ ಚೇಂಜ್ ಆಗ್ತದೆ, ಮತ್ತೆ ಸೈಟ್ ನಂಬರ್ 1 ಚೇಂಜ್ ಆಗ್ತದೆ ಅಷ್ಟೇ. ನೋಡಿ ಚಾರ್ಟ್ ತೆಗಿರಿ ನೋಡಿ.
One more request my lord. There are almost 10 matters are there. All matter may be connected because similar order has to be passed. That's like my request.
ಅದು ಲಿಸ್ಟ್ ಆಗ್ದಲೇ ನಾನು ಕನೆಕ್ಟ್ ಮಾಡಕ್ಕಲ್ಲ. ನೀವು ಕೊಟ್ರೆ ಮೂವ್ ಮಾಡಿ ಒಟ್ಟಿಗೆನೆ ತಗೊಂಡ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ.
Please my lord, please my lord.
ಯಾವ ನೀವು ಮೂವ್ ಮಾಡಿ ಒಟ್ಟಿಗೆ ಹಾಕೋಣ.
Please my lord, this matter may be also.
ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಮಾಡಕ್ಕಲ್ಲ. ಈ ಮ್ಯಾಟರ್ ಈಗ ಆಲ್ರೆಡಿ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅಷ್ಟೇ.
Please my lord, please.
31 ಇದು ಡಿಸ್ಮಿಸ್ಡ್ ಅಷ್ಟೇ. ಸೇಮ್ ಒಂದೇ ಸೈಟ್ಸ್, ಅದೇನೋ ಜನರಲ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಅದ ಬೇಸಿಸ್ ಮೇಲೆ ಏನೋ ಮಾಡಿ.
Please my lord, the power attorney and affidavits.
ಹೌದಲ್ಲ? ಎಸ್ ಹೇಳಿ ಅನಿಲ್. ಪಾರ್ಟಿಷನ್ ಅಂಡ್ ಪೊಸೆಷನ್. ರಿವರ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ರಿವರ್ಸ್ಡ್ ಅಂಡ್ ಗ್ರಾಂಟೆಡ್ 724 ಶೇರ್.
Survivors of Abdul Mansur Khan. In fact, the death certificate is there and the issue is also friends. In fact, he is the fact he demised on 21/5/2009. And there's a document is exhibit B3. And the exhibit B5 failure process. The property is obtained with the appellant number 1 to Muda failure. B5 it is the exhibited in the year 2010. Subsequent to demise and failure comes with the name of appellant number 1. So this submission is as of the death of whom I'm claiming. He has no vested right in the property. He has no right in the property by survivors, the Mohammedans, only by demise they would have got the right. But they do not having a right. And as regards to the relationship of respondent 22 with the deceased, there is a dispute. The trial court has held that the relationship is not true. The court has heavily relied upon survivor certificate obtained by them, which in fact is clearly says relied only on exhibit P4 and came to the conclusion. And also on exhibit P1, which is the Nidhanama before the court, where the Kazi was not examined, it was Urdu translated copy of price, which apparently shows that she has signed in Urdu that dollar deposition and the court documents are signed in English.
Issue notice and also the call for records. The trial court and also the first appellate court and list this matter on 12/4. ಏನು FDP ಹಾಕಿದಾರಾ? ಸ್ಟೇಜ್ ಇದೇನಿದೆ ಸ್ಟೇಜ್ ಏನಿದೆ ಗೊತ್ತಿಲ್ಲ, ಅಷ್ಟೊಳಗೆ ಹೋಗಿ ಬರ್ಲಿ ನೋಡೋಣ. 12/4 ಏನಾರು ಇದ್ರೆ ಮುಂದೆ ಡ್ರಾಯಿಂಗ್ ಆಫ್ ಫೈನಲ್ ಡಿಗ್ರಿ ಅವತ್ತಿನ ದಿವಸ ಸ್ಟೇ ಮಾಡೋಣ. ಲೆಟ್ ದೇಮ್ ಅದರ್ ಸೈಡ್ ಕಮ್. ಎರಡು ಕನೆಕ್ಟೆಡ್ ಮೇಡಮ್. ಅಲ್ಲ ಅದೇ ಸೇಮ್ ಇದೆಯಲ್ಲ, ಎರಡು ಕನೆಕ್ಟೆಡ್. 32 TN ವಿಶ್ವನಾಥ್. For declaration and injunction.
Injunction was granted by the and
Now the plaintiffs before the court. Now plaintiffs are before the court. Anyhow, divorce and pending, issue notice and call for records and list this matter for ಸ್ಟೇ ಏನ್ ಕೇಳಿದ್ರಿ? ಮೊದ್ಲೇನು ಎಂಟ್ರಿ ಮಾಡಿರ್ತ ನಿಮ್ಗೆ ಸೂಟ್ ಹಾಕಿದಾಗ ಇಂಜೆಕ್ಷನ್ ಇತ್ತ? ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿವರ್ಸ್ ಮಾಡಿ ಸೂಟ್ ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅದೇನಾ ಓನ್ಲಿ ನೋಡಿ. Third, the counsel appearing to the appellant and IA 1/19, wherein the appellant prayed this court to stay the judgment and decree of the court. Counsel would submit that the trial court granted the relief of permanent injunction restraining the defendant by way of permanent injunction. It is reversed by the first appellate. The counsel also would submit that the appellant has enjoyed the temporary injunction. Temporary illilva? Admission. The counsel would submit that and counsel brought to notice cross-examination of DW1 wherein he has categorically admitted that the Road Gordon is being run by plaintiff Subaya, and he said plaintiff Subaya is no more and his son is running the same, and this clearly discloses that 90 is in possession of the suit schedule property. The part of it, trial court has reversed the finding, and hence judgment and decree of the trial court of the first appellate court has to be stayed. And consider the material, also the submission of the counsel appearing for the appellant, and also having considered the admission given by DW1 in the class examination, it is appropriate to take judgment and decree of the first appellate court. Is this matter on records call for order madidini. Is this matter on 12/4. Karthik PM. Yes, counsel. Records ಬಂದಿದೆ ಇದರಲ್ಲಿ ರಿವರ್ಸಲ್ ಇದೆಯಲ್ಲ ಡೈವರ್ಜೆಂಟ್ ಪೆಂಡಿಂಗ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ ಬಂದಿದೆಯೇನ್ರಿ ಇಲ್ಲ ನೋಡಿ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಡೈವರ್ಜೆಂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ ನೋಡ್ಬೇಕಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ನ ಆಯ್ತ್ರಿ ರಿವರ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಫಸ್ಟ್ ಡಿಕ್ರಿ ಆಗಿದೆ ಆಮೇಲೆ ಡೈವರ್ಜೆಂಟ್ ಪೆಂಡಿಂಗ್ ಮಾಡಿದ್ದಾರೆ ನೋಡ್ಬೇಕಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ನ ನೋಡಿ Registry is directed to get the records of the trial court and first appellate court and list this matter on 13/4. List this matter for admission along with TCR. 34. Already executed. 13 along with copy of sale deed dated 24/2/22. ಏನ್ರಿ 22 ಆಗಿದೆ ಏನ್ರಿ ಸೇಲ್ ಡೀಡ್ ಆಯ್ತು 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 that was reversed in the appeal and already now sale deed is also executed. What is there decide now? Number 18. 18 ಹೌದು appeal ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟಿಗೆ ಬಂತು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟಿಗೆ ಬಂದಿದೆ ಅದು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೌದು ಈಗೇನ್ ರೈಸ್ ಮಾಡ್ತೀರಾ ಅದನ್ನ whether you have contested the matter or not counsel before the district court. ಆಯ್ತ್ರಿ ಈಗ ಆಲ್ರೆಡಿ ನೀವು ಸೇಲ್ ಡೀಡ್ ತಗೋಬಿಟ್ಟಿದ್ದೀರಿ ಮತ್ತೇನಿದೆ ವಾಟ್ ಇಸ್ ದೇರ್ ಟು ಡಿಸೈಡ್ ಏನ್ರಿ ಆಲ್ರೆಡಿ ಸೇಲ್ ಡೀಡ್ ವಾಸ್ ಅದೊಂದೇ ಗ್ರೌಂಡ್ ನೋಡಿ appearing to the appellant would submit that appeal was wrongly filed before the court instead of senior civil judge. Houda? And counsel appearing to the respondent brought to notice of this court that earlier appeal was filed before the senior civil judge. Alendre RA number 111 2014. And for the administrative reasons, the same was transferred to the appellate court, and the same was renumbered as RA number 150 of 2020. So the appellant cannot find fault with the respondent. The counsel also would submit that even after the transfer of the matter, also argued the matter before the district court, and now they cannot contend that the judgment and decree of the appellate court is without jurisdiction. Having heard the appellant counsel and also the counsel appearing for the respondent, and no dispute that earlier appeal was filed before the senior civil judge, and thereafter the same was transferred to the district court, and district court also considered the appeal on merits, and hence the said contention cannot be accepted. Apart from that, the counsel appearing to the respondent also would submit that in terms of the judgment and decree of the appellate court, already sale deed has been executed in favor of the respondent on 24/2/22. And forum number 2 also filed before the court. Then the matter has already been considered by the executing court and sale deed already been executed in favor of the respondent in terms of the judgment and decree of the appeal in RA number 150 of RA number 150 of 2020. I do not find any reasons to keep this matter pending, and appeal becomes infructuous in view of execution of the judgment and decree of the order passed in appeal. Accordingly, RSS disposed of. Raghavendra Kulkarni.
Immediately madam, this is a government land. Around 54. Put a measure 200 acres. But there is no money.
Ready Dirala? Government land.
This is a government land. You are survey number 54 is claimed around 54. There is 5 acres 3 guntas. But the facts are the grant certificate. It's not only grant for 5 acres. Not 5 acres, 3 guntas. That has to be one. But try court matter, kind of see try court finding matter. Page number 81, issue 192. They don't dispute that survey 54 measuring 5 acres. Situation Lalu Naganadi Kavala village granted in Sharhom Subrao. But can you see the decree model? Decree page number 99. But the land clearing 54 block number Lalu Naganadi Kavala village, Igwa Holding, Mesu Kavala, measure 5 acres, 3 guntas are the decree granted. Out of this model, 2 acres and 1 acre sold by the plaintiff to the Ratnamma and Kuttappa. That is also pleaded by the defendant in the trial court and appellate court. But this decree is challenged by the appeal by the defendant 7 appellate court.
Out of 5 acres, 3 guntas alli ಮಾರಾಟ ಮಾಡಿದಾರ.
3 ಎಕರೆ 2 ಎಕರೆ 1 ಎಕರೆ 1. Ratnamma ಎರಡು ಇಬ್ಬರಿಗೆ 3 ಎಕರೆ 2 ಎಕರೆ 1 ಎಕರೆ ಸೇಲ್ ಆಗಿದೆ. ಆಯ್ತು. ಅದರ ಬಗ್ಗೆ ನಾವು ಡಿಫೆಂಡರ್ ಅಪೀಲ್ ಮಾಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಪೀಲ್ ಕೋರ್ಟ್ ಅದು ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ನಾಟ್ ಇಶ್ಯೂ ಕರೆಂಗ ಸೇಲ್ ಆಗಿದೆ ರಿಸಲ್ಟ್ ಮಾಡಿ ಈ ಅಪೀಲ್ ಕೋರ್ಟ್ ಮಾಡ ಈ ಅಪೀಲ್ ಕೋರ್ಟ್ ಕರೆಸಿ ಹೇಳ್ ದಟ್ ದೇ ಫೌಂಡೆಡ್ ಡಿಸ್ಪ್ಯೂಟ್ ಫೌಂಡೆಡ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದಾಗ ಸೂಟ್ ಸೆಕ್ಷನ್ 61 ಆಫ್ ದಿ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಆಕ್ಟ್ there is a bar to enter the dispute court only a revenue court decide in respect that matter carries judgment of some court 2007 IRS Karnataka 5106 page number 19 the appeal court referred judgment but wrongly the appeal is dismissed
ಏನು ಇದು ಸರ್ವೆ ನಂಬರ್ ಅನ್ನ ರೀ ನಂಬರ್ ಆಗಿದೆ 85 ಆಗಿದೆ
ಇಲ್ಲ ಅದ ಬಗ್ಗೆ ನೋಟಿಸ್ 85 ಬಗ್ಗೆ they don't 85 54 there is a 5 to 8
already if you have sold the property to the extent of 2 acres and 1 acre out of this land, how you can maintain a suit for extent of 5 acres 3 gunta? ಸೇಲ್ ಮಾಡಿ ಏನು ಹಾಕಿಲ್ಲ ಎಕ್ಸೆಪ್ಟ್ ಪ್ಲೀಡಿಂಗ್
21 ಇದೆ 21 ಸೇಲ್ ಮಾಡಿ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ ಅದರ ಮಾಡಿದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ
ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ ಮೇಡಮ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಎಲ್ಲಿದೆ ಸೇಲ್ ಡೇಟ್ ನೀವು ಹಾಕಿರೋದು
P1 ನೋಡಿ P1
P1
21 ಅದೊಳಗೆ 20 ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಸೇಲ್ ಡೀಡ್
17 to 21 5 certified copies of sale deeds ಅಂತ
ಅದೇ ಏನು ಸೇಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಈಗ ಅದೇ 21 ಸೇಲ್ ಡೀಡ್ 2 ಎಕರೆದು
ನೀವೇ ಹಾಕಿರೋದು ಎಕ್ಸಿಬಿಟ್ 21 ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ಬಿಡು ನೋಡು
ಇಲ್ಲ ಇಂಟರ್ವ್ಯೂ ಮಾಡೋದು ನಾನು ಅಪ್ಲೈ ಕೊಡಿ ಸ್ಟೇ ಡಿಗ್ರಿಗೆ
ಏನಂತ
ಅದು ಇಂಟರ್ವ್ಯೂ ಮಾಡೋದು ಡಿಗ್ರಿ ಆಗಿಲ್ಲ ಡಿಗ್ರಿ ಇಂಜೆಕ್ಷನ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಗ್ರಿ ಆಗಿದ್ದು ಸ್ಟೇ ಆಗಿತ್ತಾ
ಹೌದು ನಾ ಅಪೀಲ್ ಸ್ಟೇ ಆಗಿತ್ತು 55 ಇದೆ ಸ್ಟೇ
ಹಾಕಿ
ಸ್ಟೇ ಆಗಿತ್ತು ಅದಕ್ಕೆ ಆ ನಮಗೆ ನಾವು ಡಿಗ್ರಿ ಸ್ಟೇ ಮಾಡಬೇಕೀಗ ಅರೆ
counsel appearing for the appellant. Any copy kudiyodu? The appellate court ಅಲ್ಲಿ stay ಇತ್ತು ಅಂದ್ರಲ್ಲ ಕೊಡ್ರಿ. Appearing for the appellant. ಈಗ could heard on IA 1 of 22, wherein the judgment and decree of the appellate court the appellant counsel has filed an application in order 41/5 of CPC praying this court to grant stay of judgment and decree passed in OS number 704 of 2010 dated 4/9/2019 passed by the first additional senior civil judge and CJM at Mysore. Counsel in support of his argument also placed the document of order passed in RA number 403 of 2019 that the first appellate court directed parties to maintain status quo as regards the nature of the property, documents relating to the property, and shall not do any act which would change the nature of the property as on this date. That is only maintain status quo. One ನಿಮಿಷ. CJM at Mysore is stayed till further orders. And also the appellate court stayed. The judgment and decree passed in OS number 704 of 2010. And hence the counsel praised this court to stay the judgment and decree of the trial court. ನೀವು ಕೇಳಿರಿ trial court ಹೇಳ್ರಿ ಅಂತ ಆಯ್ತ್ರಿ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ರೆ ಇಲ್ಲಿ ಆರ್ಡರ್ ಇರೋದು ಓನ್ಲಿ ಮೇಂಟೈನ್ ಸ್ಟೇಟಸ್ ಕೋ ಅಂತ ಇದೆ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಷ್ಟೇನೆ. ಜಜ್ಮೆಂಟ್ ಅಂಡ್ ಇದು ಡಿಗ್ರಿ ಸ್ಟೇ ಆಗಿದೆ, ಈಗ ಅದನ್ನು ಸ್ಟೇ ಮಾಡೋಣ ಅಷ್ಟೇ. ಸ್ಟೇಡ್ ಇನ್ ದ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ. ಆಯ್ತ್ರಿ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಅಪೀಲ್ ಅಲ್ಲಿ ಸ್ಟೇ ಇದೆ ಥ್ರೂಔಟ್, ಈಗಲೂ ಅದೇ ಮಾಡೋಣ ಅಂತ ಕೇಳಿದೆ. ಏನು ಮತ್ತೆ ನಿಮ್ ತಕರಾರು ಏನಾಯ್ತು ಮೇಡಮ್? The counsel appearing for the respondent who submits that the respondent is in possession of restricted property and hence the trial court granted the relief of decree as sought, and also the first appellate court also confirmed the judgment of the trial court and hence no grounds are made out. Having considered the material on record and particularly in RA number 403 of 2019, the first appellate court also stayed the judgment and decree of the trial court. In such being the case, it is appropriate to stay the judgment and decree of the first trial court. Trial court in the next date of hearing. In the meanwhile, register is directed to get the records of the trial court and first appellate court and list the matter along with the PCR for admission on 13/4. ಬೇರೆಯವ್ರಿಗೆ ಯಾರು ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ಯಾರೋ ಇದಾರ ಬೇರೆ? 5 ಜನ ಇದಾರ. ನೀವು ಒಬ್ರಿಗೆ ಮಾತ್ರನಾ? R1 ಮಾತ್ರ. ಆಯ್ತು, issue notice against other respondents. And appellant counsel is directed to create process forthwith. Process ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮುಂದಿನ ಸರಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ರೆಕೇಟ್ ಆಗ್ತದೆ ಅದಕ್ಕೆ. ಆಯ್ತು, ಉತ್ತರ ಪಾಪಿ ಕೊಟ್ನಲ್ಲ 13/4. One-fifth share, item number 1, 2 to 4 dismissed. Item number 1 ಕೊಟ್ರು, 2 to 4 dismiss ಮಾಡಿದ್ರು. ಅಪೀಲ್ ಅಲ್ಲಿ ಏನಾಯ್ತು? ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ಮತ್ತೇನು ಗ್ರೌಂಡ್ ಏನು?
father, the different of the man and husband of the client. Parallel of the event.
Oh, then appeal only in respect of dismissing of the item number 2 to 4. I can round down on that. Second appeal. Can admission put either. Trial court judgment. Para 11. The plaintiff in order to prove that social properties are joint in the family properties. Plaintiff and defendants and they are in joint possession of the same in order to discharge the burden on the same. The plaintiff number 1 has filed the evidence of it. So and so, so and so. But this admission of DW1, in the course of process DW1, she categorically deposes that number 2, Manaya Sotu, Vandane Prativadi Nagaratna, Yadane Prativadi BP Sudarshan, Vandane Vadia Gandanada, Angada Pratapa Simar ಅವರಿಗೆ ಮರಣ ಶಾಸನದ ಮುಖಾಂತರ ಬಂದಂತ ಸ್ವತ್ತು ಆಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಮರಣ ಶಾಸನ ಯಾರ್ದು ಬರ್ದಿರೋದು? ಅದು ಇದು ಯಾವ್ದು ಪ್ರಾಪರ್ಟಿ ಇದು? ಐಟಮ್ ನಂಬರ್ 2, ಐಟಮ್ ನಂಬರ್ 2, 3 and 4 ಕಿಲ್ಲ ವೆಹಿಕಲ್ಸ್. ಇದಕ್ಕೇನು ಆನ್ಸರ್ ಮಾಡಿದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು? But this admission of DW1 itself is not confer any title over the item number 2 of the social property to Angadarappa Simha and defendant number 1 and 2 herein. But the plaintiff has not produced any documentary evidence to substantiate the same. In the absence of the same, the plea of the plaintiffs is not acceptable in the eye of law. It is very pertinent to note that the plaintiffs have not produced any documents. Remove properties item 3 and 4 of the social properties were also joint family properties. In the absence of the same, item 2 to 4 of the social property. Appellate court or any. ಏನದು ವಿಲ್ಲ ವಿಲ್ಲ ಹಾಕಿದೀರ? ಅವ್ರು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು ವಿಲ್ಲಿನ ಬಗ್ಗೆ. ಆಯ್ತು, ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಏನ್ ಹೇಳಿದ್ರು? ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್ ಏನ್ ನೀಡ್ ನಾಟ್ ಬಿ ಪ್ರೂವ್ಡ್ ಅಲ್ಲೇನ್ರಿ? ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ? ವಿಲ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಮತ್ತೇನ್ ಬೇರೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ? ಐಟಮ್ ನಂಬರ್ 2 ಸಂಬಂಧಪಟ್ಟಂತೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಯಾವ್ದು? ಟ್ಯಾಕ್ಸ್ ಅಸೆಸ್ಮೆಂಟ್ ರಿಜಿಸ್ಟರ್ ಎಲ್ಲ ಹಾಕಿರಿ? ಈಗ ಹಾಕಿದ್ದೀರಾ? ಐಟಮ್ ನಂಬರ್ 2 ಐಟಮ್ ನಂಬರ್ 2ಗೆ ಇಶ್ಯೂ ನೋಟಿಸ್ against the respondents on main and also on IS. Here put and discuss matter on 13/4.
No, I appeal for the appellant in this matter, madam.
Yes, counsel.
There is a case where suit is filed by respondent number 1 for partition separate portion. This suit is among sisters, Miller. What has happened is the father got the properties at a partition of the year 1996, Miller. He had left behind him his wife and 4 daughters. And in the year 2007 and 2008, mother, after the death of the father dies on 28/4/2004. And after the death of the father, the mother executes 2 gift deeds, Miller. One in the year 2007 in favor of defendants 1 and 2. This appeal is by defendant number 1. On 28/2007, in respect of items 1 and 2, the mother executes a gift deed in favor of defendants 1 and 2. On 2011/2008, as per exhibit P2, mother executes another gift deed in favor of plaintiff defendant number 3.
Defendant number 3.
Defendant number 3.
In respect of the same property or different?
Item number 3.
Item number
1
3.
and 2 are given to plaintiff.
1 and 2,
1 and
D1
2.
and D2.
Yes. Item number 3 was given to defendant number 3. There is a registered deed. Now the suit is filed in the year 2017 by the plaintiff, seeking for partition in respect of all the properties, saying that Millard, she is not aware of these registered gift deeds, and questioning the right of the mother to execute the gift deeds in favor of the other daughters.
But property belongs to whom?
Millard, am I audible, Millard?
Yes, property belongs to whom?
Millard, am I audible, Millard?
Yes,
Millard.
I am able to hear
Millard,
you. I am able to hear you.
Video. Hello. Video interruption in ಆಗ್ತಾ ಇದ್ದಂಗಿದೆ.
I am able to hear you, counsel.
Hello.
ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ ಸರ್?
ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ? I am able to hear you.
Hello.
I am able to hear you, counsel.
Hello, sir.
ಏನಾಯ್ತು ಮತ್ತೆ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಯ್ತು. ಇದನ್ನು ತಗೊಂಡ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ. ನೋಡಿ ಈಗೆಲ್ಲ ಮುಂದಕ್ಕೆ ಎರಡು ಇದೆಯಲ್ಲ ಶೂಟ್ ಅವ್ರದ್ದು ಏನಾಗುತ್ತೆ ನೋಡಿ.
ಎಲ್ಲರೂ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು
ಅಲ್ವಾ ನೋಡಿ. Counsel appearing for the appellant. You see. At the same interrupted. Got disconnected. And as this matter on 31st, 31 week. Yes, Chandrachud or Nimde. Awaiting notice of R1 to 4. ಬಂದಿಲ್ಲ ಇನ್ನು ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿಲ್ಲ ನೋಡಿ. Await notice of R1 to 4. This matter on 31/3. Next 39.
To supervise the land and cultivate the land. He must permitted. Yes, finally, the statement dealing the all the others seriously disputed the ownership of the planting. And here contained that the certain the Suda's property is not a part of 7/93. The part of 7/97. assessment as 157. He has constructed the farm with his own money. And we all the record of the name of the based on the accounts, the owes 926 for 2022 was taken to mind. It was a variation, wherein we can take a decree. The present plaintiff is one of the
party in that suit.
So the injunction to take a decree. As in that order, the plaintiff has become an RA, and in the pendency of OS 296, the original plaintiff gave us the grant. In RA, the LRs are present in the matter. And RA is dismissed the way. The member is saying that the after death of the original the plaintiff, the LRs cannot be present. The RA can be dismissed on the interpretation. In the advantage of that, the both court has come to the conclusion that the RA 9/2004 reached finality. Then this defendant has not challenged the RA 9/14, the 4/18.
RA 9 of 2014 is based on the merit, whether it dismissed on merits.
Yes.
Dismissed on merits.
Yes, the LRs have not went to proceed. Based on mentality and merits on the RA can be dismissed. So after dismissing the RA, the present plaintiff filed the OS for declaration respect of property. Containing that property as part of the 293.
We are allowed. He published the election. He went to the adverse position. That was negative. Election was granted. That he was a caretaker. Election was granted. After that, I filed the appeal. In RA 9 of 2004. Of 2005 and exhibit 322. Holding that Virat is a caretaker, his position is as good as my position. He is not entitled for injection following the judgment.
Lower court. Madam, records ಬಂದಿರಲ್ಲ first time list ಆಗಿದೆ.
Both the courts are guided that he is not having any right. Both the courts are under time that I got purchased by me. In 1963 it was granted to me. He is he has made 3 suits for fight. Occupancy right was trying to buy them before the state comes down. That was also rejected. First suit was in year 2002. That was dismissed as per RA judgment. Then we got second suit was in 2005. That was also dismissed. Third suit
all suits are for the relief of
injunctive. That was dismissed. And we order. First suit, it is said that we are very true at the and perfect that 95 adverse position. That you are also thinking that
defendants are hereby directed to vacate and hand over the possession of the property.
In 1992, this is declassified these two.
Now there are several suits and
yes, several suits.
Judgments.
All suits will not went against it.
The records barely. Records ಬಂದಾಗ
I was constructing the building and I'm decided for the past 35 years. Now subsequently I come to the declaration. All regulators will say in the name of the
this court also to examine on what capacity you are in possession. That has to be considered by this court.
Even though all regulators, panchayat kata was affected in my name. I got permission in the panchayat, panchayat people license building.
But what is your claim for the relief of? Only you are in possession.
I was sitting for the past 35 years. So for me, any disturbance to anybody. So what their contention is?
Your claim now is you are claiming adverse possession. Then adverse possession you have to prove certain aspects with regard to the continuity of possession and animus possidendi also you have to prove.
So I am the adjacent one of the property within 764 to the extent of 28 acres. There is no survey report says that whether this super property belongs to my property or her property. She has not produced a single document to show that these super property.
Now you cannot contend that. Once you contend that you are perfected the title by adverse possession, first you have to admit the ownership of the plaintiff. The recent judgment of Supreme Court 2022.
And we are not perfected rectified work for it.
Let the records come. We will examine. Records entry ಮಾಡಿದ್ರೆ ಏನಾಗಿದೆ hand over the possession ಅಂತ ಆಗಿದೆ ಅಲ್ವಾ?
Now we are trying to discuss it from the landing question by filing the execution petition.
Execution ಈಗ already file ಆಗಿದೆಯಾ?
Lawful possession. He is absolved from containing anything else not in it. Which is a good point for me for declaration and for evasion or in the ordinary possession. What is what called order lacking?
He is not claiming the title. He is claiming only adverse possession.
Adverse possession is negative because
Counsel, when you are disputing the survey number is concerned, how you can claim the adverse possession? That is the point. Now you cannot contend that no, it is not comes in survey number 293. No, counsel, why court has to conduct survey now? Your claim is that you have perfected the title by adverse possession. Unless you admit the ownership of the original owner, how you can claim, counsel, how you can claim adverse possession unless you admit ownership of the plaintiff? No, counsel. If that is the case, no ground. Have you pleaded adverse possession or not? Other issue. That is an issue. Now how you can dispute that he is not the owner? No, this property not survey number 293 and 97. Now you cannot dispute the identity of the property. Identity of the property, you cannot dispute it. Only this court can secure the records and till next date of hearing. I will fix the date, I will fix the date. I will stay next date of hearing. In the meanwhile, ಎಲ್ಲಿ ಅಲ್ಲ ಆಯ್ತು ಏನ್ ಹಾಕಿದಿರಿ ಆಯ್ತು ನೀವು ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ 18th ಇದೆಯಾ ನಾಳೆಗೆ ಆಯ್ತು ನಾಳೆ ಹೋಗಿ ಅಪಿಯರ್ ಆಗಿ ಅಷ್ಟೇ ತಗೊಳ್ಳಿ ಮೇಡಮ್ clear ಆಗ್ತದೆ ತಗೊಳ್ಳಿ ಏನಾಯ್ತು ಮೇಡಮ್ ಹರ್ಡ್ ದಿ appellant counsel and also the counsel appearing for the respondent and this appeal is against the concurrent finding of both the courts and our counsel also appearing for the appellant has filed IA 1/23 for stay and in support of his contention also he contend that already execution petition is filed before the executing court and matter is listed for tomorrow. And having perused the material on record, there are litigations between the parties. Such in the case, it is appropriate to call for the records of the trial court as well as the appellate court. And in the meanwhile, the stay is granted till next date of hearing. Yavurdidu? Next date of hearing. The registry is directed to list this appeal along with records of the trial court and first appellate court for admission on 12/4. ಇನ್ನು ಬೇರೆಯವರು ಯಾರಿದ್ದಾರಾ ಯಾರಿದ್ದಾರೆ ಬಟ್ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ 20 ಜನ ಇದ್ದಾರೆ ಯಾರು ಅವರೆಲ್ಲ ಯಾರು ಅಂದೆ ಈ ಜಜ್ಮೆಂಟ್ ಡಿಕ್ರಿ ಇನ್ ಫೇವರ್ ಆಫ್ ಹೂಮ್ ರೀ ಯುವರ್ ಕ್ಲೈಂಟ್ ಓನ್ಲಿ But you are agreed by. Huh? They are the LRs. There are some LRs there. 1D. Original suit number 98 of 2011 file matter they are raised Srimati Suvarnamma. Suvarnamma ನೀವು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ? Decree in favor of only the respond number 1. Respond number 1. So next list ಮಾಡಿ. Decree is not against in favor of others. Others ಪರವಾಗಿ ಏನಾದ್ರು ಡಿಕ್ರಿ ಇದೆಯಾ? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಮಾಡಿದಾರ? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಯಾರ್ಯಾರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದಿರಿ ಹೇಳಿ? ಆಯ್ತ್ರಿ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಯಾರ್ಯಾರನ್ನ ಇದಾರೆ? ಎಲ್ಲರೂ ಇದ್ರೆ ನೀವು ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಬಾಕಿ ಅವರಿಗೆ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿರೋದು ಯಾರು? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಮಾಡೋರ? ಹಾಗೆ how he can undertake. Decree is only in favor of him. That's the reason only he has filed appeal. That's the execution. Counsel only the decree in favor of R1. No notice. This matter and so and so along with the TCR for admission on 12/4. Decree is stay ಮಾಡಿದ್ವಲ್ಲ ಆಯ್ತಲ್ಲ till next date of hearing ಅಷ್ಟೇ. Further arguments, sir. 2:30 no sitting re. So list this matter. On. Oh, madam. 27/3. ಬಾಕಿ ಇದೆಲ್ಲ ಡೇಟ್ ಕೊಡಿ. 41 ಎರಡೇ ಇರೋದಾ? 41. 41 ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? 41/3. ಕರೆಕ್ಟೆಡ್ ಇನ್ನೊಂದು 42 ಫಸ್ಟ್ ನಗರಲ್ಲ. ಯಾವಾಗ ಬೇಕು? 31/3 ಆಗ್ಬೋದಾ? ಆಯ್ತು. ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ಯಾವ್ದಾದ್ರು ಪಾಸ್ವರ್ಡ್ ಇದೆ ಅಂದ್ರಲ್ಲ. ಏನಾಯ್ತು ನೋಡಿ. ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಾ? The counsel appearing for the appellant submit that cost is paid and also complied with office objection and hence post the matter for admission on 31/3. 11 Pradeep M. ಬೆಳಿಗ್ಗೆ ಅವ್ರು ಏನು ಹೇಳ್ತಾ ಇದ್ರಲ್ರಿ ಇದು ಎಲ್ಲ ಮಾಡಿದೀವಿ ಅಂತಾನೋ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರು ನೋಡಿ. ಒಂದು ಮಾಡಿಲ್ವಾ? ಮತ್ತೆ ಬರೀ ಡಿಸ್ಮಿಸಲ್ ಅಂತಿದೆಯಲ್ಲ ಇದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಂತ. ಕೊಡಿ ಆರ್ಡರ್ ಕೊಡಿ. ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರ? ಕಂಪ್ಲೇಂಟ್ ಒಂದು ಮಾಡಿಲ್ಲ. ಹೌದು ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ರು ಹೋಗ್ಬಿಟ್ರ ಹಾಗೆ. This appeal was listed on 3/3/23. Counsel for appellant was absent. However, this court taking into note of this appeal was filed in 2019. Granted 2 weeks time to comply with office objections and payment of cost of ₹1,000. And counsel for the appellant has paid the cost but not complied with any of the office objections. There are 16 office objections, and none of the office objections are met by the counsel, and hence the appeal is dismissed for non-compliance of office objections, since earlier order is very clear that if the office objections are not complied, this the matter for dismissal. And in view of the preemptive order dated 3/3/23, appeal is dismissed at 1:40, and in the early morning also directed to comply with office objections. In spite of it, not complied with office objections. Hear the counsel? Cost ಕಟ್ಟಿರಿ ಬಟ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದ್ರಾ? ಎಷ್ಟು ಹೋಗ್ಲಿ ಮಾಡಿದಿರ? ಸ್ವಲ್ಪ ನಾನು ಎಷ್ಟು ಮಾಡಿದಿರಿ ಹೇಳಿ. ಇನ್ನು ಎಷ್ಟಿದೆ? 4ನಲ್ಲಿ 2 ಇದೆ. The counsel appearing to the appellant to submit that he has paid the cost of ₹1,000, and out of 4 office objections he has complied 2 office objections and remaining office objections. So another 2 weeks time granted, and further is 500, And if further cost not paid and office objections not complied within 2 weeks, this matter for dismissal on 31/3. It's one only idea. ಏನಾಯ್ತು? ಬರ್ಲಿಲ್ವಾ? ಹಾಕ್ಕೊಡಿ. The council has filed memo. The council has filed memo for the appeal. But already this court has dismissed the appeal. And IA 1/23 under 1/23 is filed for recalling the order dated 17/1/23. And the appellant counsel ought to have filed a memo not pressing the IAS. Then list this matter. Monday na tira burutta Monday, sorry Monday. Tena 17 ಏನಿದು? ಏನಿದು? ಬರೋದೇ ಇಲ್ಲ ಕೌನ್ಸಿಲ್ ನೀವು ಯಾಕೆ? Last time absent told the appellant counsel 6 times list this matter on.
The dean season. Pronouncement.
ಜೋರಾಗಿ ಪ್ರೆಸ್ ಮಾಡಿದೆ ಅದು ಇವೆಲ್ಲ ಗಟ್ಟಿಯಾಗಿ ಬರ್ಲಿಲ್ಲ ನೋಡಿ ಸರಿ ಆಗುತ್ತೆ ಇಲ್ಲ ಬೇರೆ